Whereas, my lord, in the previous writ, it was already very deliberately mentioned, considers representation, and but still they have taken the plea under section 44 that whereas I am not a foreigner, I'm not someone who is not a part of that company. I was a part of that company. I was one of the directors. Being a director, I might not be the authorized person presently. I might not have any signatory authority. But that is under challenge. There is NCLT order which has already stated that the status quo would be mentioned in terms of the, if I may refer to the NCLT order. NCLT order is in page number 26 of my writ application, my lord. NCLT, the matter is already pending before the NCLT, and NCLT has already held in the page number 27, paragraph number 5. In view of the facts and circumstances as mentioned above, we direct maintenance of status by the respondent company with respect to the shareholdings and the assets of the company.
Page number? Which page?
Page number 27, paragraph number 5.
Till the next date of hearing. Election hoche. Till the next date of hearing.
But that's different.
After that writ, Lordship, even after that writ, there is another effect. They have already preferred, and there was a FIR was registered against them. The FIR is saying page number 20, and against that effect in regard to the purported signature of mine. They have preferred a quashing application in that for quashing of that FIR, which was later on dismissed, holding there was no merit to that application. After that, after the institution of this writ application, it has came to our knowledge that they are still continuing such kind of things. They are still continuing this taking by advancement of loans in the company, and in that regard, we have already prepared a complaint, and that complaint has already been registered. My lord, what I only seek for is to be given a copy of a detailed bank statement of the company, because I am one of the directors. I was one of the directors of the company. This is my only prayer before the court.
Who appears for the bank?
Well, for the VAP for the private response, our main contention here, it's non-justiciable. It's not meant to be a petition. On a lawyer's notice, you ask for a detail from a bank account. That's precisely dealt with the bank in the last letter. That's been precisely. That's the only one. There are several writ petitions pending between the parties. In a drop of a hat, they file a writ petition. That's it. But they were here, my lord. What we were suggesting them, my lord, they haven't filed an application before the NCLT seeking on the grounds of misrepresentation, mismanagement, and all that stuff. 4 and 5, 4 and 6 petition is pending. But if the director of the previous director, whoever wants foreign record, will always approach to the NCLT and ask call for. That's a separate forum, separate stand. But here, my lord, writ petition, earlier writ petition, my lord, will see they had made 3 banks a party. That was dismissed. They said that, okay, State Bank is a party, you State Bank deal with the issue. State Bank has dealt with that issue. State Bank has categorically said it's these correspondence is privy between the customers and the bank. It cannot be disclosed by lawyers. It is non-justiciable. That's my only ground.
The bank not for the state respondent. Respondent number 1.
Right.
The petitioner has preferred the present writ petition, challenging the reply/communication issued by the respondent number 2, whereby the request of the petitioner for disclosure of the detailed bank statements pertaining to respondent number 3 and 6 have been declined. Full stop. Learned counsel appearing for the petitioner submits that the petitioner was one of the directors of respondent number 3 company and was also a director of respondent number 6 company from 17 11/1993 till 30th of December 2016. Full stop. It is further submitted that the petitioner continues to hold shares in the company. Full stop. Learned counsel for the petitioner submits that the petitioner has knowledge that the respondent number 6 company has availed substantial loan facilities from respondent number 2 bank as well as other financial institutions. Full stop. In such circumstances, the petitioner sought for detailed bank statements of the said companies by way of representation in order to ascertain the financial dealings to safeguard his interest as a shareholder. Full stop. It is submitted that the respondent number 2 failed to furnish the requested information, comma, the petitioner had approached this court by filing petitioner approached this court by filing WPA number 2632 of 2024. Full stop. By order dated 21/1/2025, this court disposed of the said writ petition, directing the respondent number 2 consider and decide the petitioner's representation. Full stop. Pursuant to the said order, respondent number 2 passed the impugned reply dated 5/2/2025, rejecting the request of the petitioner. Learned counsel for the petitioner contends that the said rejection is arbitrary, unreasonable, and contrary to law, inasmuch as the petitioner, being a former director / shareholder, is entitled to access such information relating to the affairs of the company. Full stop. Per contra, from the impugned reply, it appears that respondent number 2 has rejected the request on the ground that the petitioner is not an authorized signatory of the concerned borrower companies and is not duly authorized by the board of directors to transact or communicate with the bank on behalf of the company on behalf of the respondent companies in respect of the credit of its credit facilities. Full stop. It has been further stated that the bank is under no statutory obligation to maintain the bank is under no statutory obligation to provide such information to the petitioner. Full stop. The letter further states that the bank has to maintain a statutory obligation of confidentiality and secrecy of its customers' account and cannot disclose such information to third parties in absence of proper authorization. It is noted that the petitioner was not supported by any board resolution or authorization from the company. Full stop. Heard counsel for the parties and have perused the materials on record. Full stop. The short question which falls for consideration is that whether the petitioner, in his individual capacity as a director / shareholder, can seek a writ of mandamus directing the bank to disclose detailed bank statements of a company which is a separate legal entity. Details of a company, directing the bank to give details of a company which is a separate legal entity. Full stop. It is a settled principle of law that a company incorporated under the Companies Act is a distinct legal entity, separate from its shareholders and directors. Full stop. The affairs of the company are to be conducted by its board of directors in accordance with law and in terms of the article of association of the company. Full stop. In the present case, admittedly, the petitioner approached the bank in his individual capacity without any authorization from the board of directors of the concerned companies. Full stop. There is nothing on record to demonstrate that the petitioner is an authorized signatory or has been empowered by empowered by a valid authorization from its board of directors to seek such information from the bank. Full stop. The relationship between bank and its customer is governed by the duty of confidentiality. Full stop. The bank cannot disclose the financial details of its constituent to a third party except under circumstances recognized by law or upon proper authorization. Full stop. In the absence of such authorization, the bank would be justified in refusing disclosure to the petitioner. Full stop. Disclosure of information sought by the petitioner. Full stop. The contention of the petitioner that he is a shareholder and former director does not itself entitle him to seek disclosure of the bank statement directly from the bank, bypassing the corporate structure and internal governance mechanism of the company. Full stop. In such circumstances, this court finds no illegality or infirmity in the decision of the respondent number 2 as contained in its reply dated 5/2/2025. The present petition is devoid of any merit. The same is dismissed.
Grateful.
Affidavit of service recovery. Directly from the bank, unless a valid authorization has been issued by its board of directors. Next.
Item number 2.
Malad, you are for the Malad, I am for the respondent, Malad.
Why? Why? What happened?
Malad, they are trying to avoid this matter. I would be very candid on that.
Why pass over? You're doing the matter.
Yes.
What happened? Why are you seeking a pass?
My lord, just 5 minutes possible.
Malad, may I address the court, Malad?
Not no. Why should I give you a pass over? You are doing the matter. Why should I give you a pass? Yes, sir. What is the matter?
I have taken the by way of transfer of possession. I have taken possession of a particular chunk of land, which is a wasted land, present, which is not no patta has been issued by the municipal corporation or by the proper or by the authority till date, despite of several representations. In that premises, I have constructed a building. I have been given my holding tax. I am paying my holding tax. I have been giving, that is page number 32 annexure B2 of my annexures. Sure. I have been giving my holding tax in regard to that premises.
Do you have a sanction plan?
No.
No, my lord, I don't have a sanction plan. As per that, it is not about it is not the matter of just my building. It is a whole locality. That whole locality has been established upon a chunk of wasteland. No patta has been issued, and if we do not have the patta, we cannot apply for the building plan, sanctioned building plan. And in that whole locality, where more than 10 lakh people, 2 to 3 lakh people are staying, everyone is staying with the assurance that has been given by the municipal corporation and by the concerned government authority. Because we have approached them several times, where I have taken the possession of that particular land in the year of 2000. Before that, there was a, before that,
2000 you took.
in the year of 2000.
Yes.
After that, we have not seen the whole locality, the people of the whole locality has approached the court, has approached the proper authority several times for issuance of patta, so that they can at least stay with some documents in that particular land. In that particular building, it's a 2-story building. in a very small portion of that building of mine, I am running a small general small shop. I have the proper documentation that has been issued by the corporation permanent certificate of enlistment, and I have been renewing it time to time, and I am giving my taxes. I have been issued with electricity connection in that. I am holding an electricity connection in my name. Now what happened? In the meantime, a private respondent approached us seeking. The private respondent is the respondent number 7. He approached, not me. All the documents relating to that building, to the house, is with me.
Yes.
What this private respondent approached my husband and with a extort money from him, stating that your building is illegal and if you don't give me a certain chunk of money, I will get it demolished. I have that much capacity to do that. I'll approach the court on it. What happened after that? They had preferred. I straight away, my husband straight away denied that I'll not entertain all these things. In this regard, this whole issue was already communicated with the part counsel in a written form.
Yes.
After that, they have made some representations and they have preferred a writ application. That writ application was disposed stating that writ application was disposed.
Page 70.
Considered
Page 70.
And who's this person who has filed
Neighborman.
neighbor?
they are claiming to be neighbor, whereas the adjacent land which they are claiming to be theirs, it is a vacant land. They don't even stay there. There are no residents out there.
Is what are
It is
you
a
showing?
vacant land.
What are you showing?
My lord, what happened? They have approached the court and it was directed to dispose of their representation in accordance with law. After that, what happened? A notice was issued. Notice was issued against my husband, who is not holding anything in his name regarding to that building. The private respondent was not even aware about the fact that who is the actual owner, who is holding the documents in regard to the in regard to the title or in regard to any formal documentation. Notice was issued. Notice was issued to my husband. He was called for page number 73. Notice was issued. He was called for. He went to the writ application that was earlier preferred by them. It was not at all challenged. It was not contested by the petitioner or the husband of the petitioner. Being layman and they give the thumb impressions. They don't even have the knowledge that they can approach the court, they can approach the court and get free legal aid or free legal representation for the court. They are not even aware. They are uneducated peoples. My lord, what happened after that? I was called for. I appeared before it. The commissioner who was adjudicating the matter simply asked me whether I have a building plan or not. I generally submitted that yes, I do not have a sanctioned building plan, as because certainly telling all the reasons behind it. What happened after that? I left page number 75. The order was passed and that order was communicated with me. 24/7/2025, the order was passed. In the next page, in the later portion, it has been mentioned that under as per the provisions laid down under section 287 of the West Bengal Municipal Corporation Act, which is rule 32 of the West Bengal Municipal Building Rules, the opposite party is hereby directed to remove or dismantle the unauthorized structure on or before 37/2020. A note of this order was passed. After that, after receiving this order, I asked, as because I am not someone who can read English, I asked the other people staying in the state locality. They have told me in regard, and after that, I have approached someone and I have made representations, page number 77, my lord, stating all the reasons that I have not been given any opportunity of being heard. Moreover, page number 77, and it should be that. That is my representation before the Honorable and the Commissioner. Still, I have cited all the reasons that no parte has been issued, and I have given my in the page number 80, my lord, in the later portion, it will be seen that I have categorically stated that under the I would like to request you to consider my present representation and also let me earn my livelihood and my in my respective premises till the permanent settlement and issuance of parte in this regard to my physical holding and possession of the premise. I undertake wherever the valid documents will be provided by you in regard to my holding and possession, I will apply for the building plan and obey all the rules and regulations as applicable in respect of my said premises. I have already deliberately communicated with them that all the citing everything, all the details that no parte has been issued. We have approached, we are getting before coming of this government, earlier government also, we have approached them. They have given us faith that yes, some point of time the parte will be issued, but till this day, even after changing of the government, no parte has been issued till this day in our favor. My lord, page number 82. Page number 82 is the mass representation which was given by all the locality, the peoples of the locality. Page number 85 and 86, my lord will see, my lord will find out it was a mass representation which was given by all the locality, as because this particular private respondent is in his personal grudge gain illegal to get some illegal gain from this petitioner. It is already known everyone in the locality is doing such things, whereas the whole locality where water communication is there, proper roads are there, people are paying taxes to the corporation. Documents have been issued, but parte has not been done. Even the building, which was each and every building that has been considered, the corporation has knowledge about it. Corporation has full knowledge about it. Or else the holding wouldn't have been issued. The electricity connection wouldn't have been issued in my name. My lord, my representation was also not considered. Even the mass representation was also not considered. After all these representations and mass representations that were given by me, what happened on one fine day, he came into my shop, came into my husband's shop, the private respondent, and he threatened me, and hot scuffle took place in between them, in which we, the petitioner, the son and the daughter of the petitioner and the husband, they both were, a hot altercation took place, and some fists and blows were thrown by the private respondent. And in this regard, already a particular case has been initiated. That is the annexure P11, the page number 87. Already a case has been registered and the cases has been investigated and charge sheet has been submitted. After that, what it was claimed by them, they have claimed that they have certain chunk of land in my property, which is under my possession. In this regard also, there is a title suit pending in between the private respondent and in between the private.
Why are we going there, sir? Your issue is only confined to the unauthorized construction. That's all.
Yes, my lord. What happened? Title suit is also pending in this regard, which is in the page number 2. The plate has been annexed in the page number 91. My lord, but as nothing was considered till now, I have made another representation before them, which is in the page number 100. My lord, all I seek for not to demolish the building, as because that is, if that thing happens,
Is this
I
order,
will be.
is it a appealable order? Is there any tribunal?
My lord, no, my lord, there is no trial. And moreover, my lord, what I seek for is, I was not given any opportunity of being heard. I, being the person who is having all the documents, whatever documents, my very ultra amount of documents that I have, that has been given by the government, I am holding those documents. I am the petitioner. I was not given any opportunity
All right.
of being heard in this. I will prefer a. Page number 5, my God. having considered the submissions, we are constrained to observe that unauthorized or illegal construction, commercial use of residential property contrary to the norms, rules and the regulations cannot be protected. So the determination of such fact ought to be made by the authorities, affording due opportunity to the owners and occupiers. In the present case, the direction as issued by the High Court, either in respect of jurisdiction of the civil court or for removal of the constructions, appear to be without joining the appellants as a party in the writ petition. It goes without saying that opportunity of hearing is a sine qua non for fair administration of justice, and the observation of the court should not adjudicate the rights of any parties unheard. My only grievance is I was not given any opportunity of being heard. I was not added as a party in this.
Anything else?
All I seek for is
Yes. Not to demolish.
not to demolish the pause and pause the order. I will duly comply with all the rules and regulations after the issuance of parte. If parte would have issued, I would have not.
You should have constructed after the part.
My lord, may I, my lord,
Locality is
All right.
my lord, this
Anything
entire
else?
writ
That's what I'm
petition,
asking. Yes.
My-
Yes.
a very important fact, my lord, it is a material fact suppressed deliberately, my lord, which in this grounds
Do you have
court,
any construction there?
my lord, they have,
Are you living there?
yes, my lord, my
You are a
brother
private
is living,
party.
my lord.
You are a private party. Your brother's house is there. Well, it's
My
constructed.
adjacent. My lord, they have constructed over a height
Is
drain.
your brother house constructed?
Yes.
All right, give the address. Give the address of your brother's house.
My lord, it's adjacent, I've given, my lord.
This
It's
is your
with,
brother's house.
my lord, the same neighbors.
He also has a building.
No, my lord, it's ground floor, just a ground floor. He has a title.
Title.
It's a
doesn't
registered
matter.
land having title and all the
Is
formalities.
it constructed in accordance with the
Yes,
sanction
ma'am.
plan? Where's the
Yes.
sanction plan?
My lord, that is with my brother, my lord.
Why are you showing me this?
My lord,
Who's
kindly
the
see.
petitioner?
My lord,
You are petitioner or your brother is petitioner?
my lord, this is different, my lord. This is their suit,
Why?
my lord.
Why are you showing me this?
My lord, because, my lord, they have filed a suit.
I don't need to hear you. Who's for the corporation? Yes.
What they're saying is that.
You have no locus.
Hearing has not been
Yes.
provided to him.
My lord, I was the writ petitioner, my lord.
Pursuant to the direction of the Honorable High Court,
Yes.
notices were served upon them, they appeared for the hearing,
Yes.
her husband came for the hearing, he duly participated in the hearing and according to order has been filed. At the time of hearing, they did never raise this question that the owner of the land, owner of the house is my wife, they have never taken this issue. And moreover, Lordship,
You demolish his house also. Take down.
These
Lord.
are,
Yes.
Lordship,
My lord, after
I'll
granting
give
an
a
op-
direction.
Lordship.
Take down. The petitioner has preferred the present writ petition. This order is of 24th, present writ petition challenging the demolition order dated 24/7/2025, passed by the Commissioner, Siliguri Municipal Corporation under Section 287 of the West Bengal Municipal Corporation Act 2006, read with Rule 32 of the West Bengal Municipal Building Rules 2007. Learned counsel appearing for the petitioner submits that the petitioner had acquired physical possession of the temporary structure measuring 13 feet into 15 feet with CI sheet roof bearing CI sheet roofing bearing holding number 296/254/590/112 situated at ward number 5 of Siliguri Municipal Corporation from one Mr. Bhagwan Pandey by virtue of a written agreement dated 27/6/2000 upon payment of valuable consideration. Full stop. It is further submitted that the area in question, popularly known as inverted comma medallo, Santoshi Nagar, comprises of large number of construction, both residential and commercial, allegedly raised over vested land, and more than allegedly constructed over vested land and that more than, how many structures are there?
I have 1 2-story building.
More than
Advanced
1 lakh structure exists there. Full stop. According to the petitioner, owing to the nature of the land, the corporation has not a position to sanction building plan in respect thereof. Full stop. It is contended that despite such position, the petitioner and other similarly situated occupants have been paying municipal taxes and successive government have from time to time assured regularization of such construction, though no formal policy decision has been implemented. Full stop. Learned Counsel further submits that he has raised a 2-storied structure, each floor comprising of 1 room measuring approximately 10 feet into 15 feet, and has been using the ground floor for commercial purpose under a trade license issued by the corporation in the name of Rajan General Stores, while the upper floor is used for residential purpose. He further contends that the proceedings were initiated at the instance of respondent number, you're 7?
7.
7. Respondent number 7. A neighbor occupant, who, due to personal animosity, allegedly demanded an illegal gratification of rupees 1 lakh, 10 lakhs from the petitioner. Upon refusal from the petitioner,
This is false.
the respondent number 7 lodged a complaint before the municipal authorities alleging unauthorized construction, and also approached this court by filing WPA number 735 of 2025. Full stop. This court, by an order dated
Page 71.
34/2025, passed in the said writ petition, directed the Commissioner, Siliguri Municipal Corporation, to consider and dispose of the representation of the respondent number 7 upon affecting an opportunity of hearing to the affected parties and upon conducting a proper inspection of the premises. Pursuant thereto, an inspection was conducted on 13/5/20. Is 13 or 23/5?
My lord,
Page 74, just see.
23/7, my lord. That is the
23/5.
date.
23/5/2025. Full stop. Thereafter,
7, my lord.
notice dated 11/7/2025 was issued to the petitioner, and a personal hearing was granted on 23/7/2025, sorry. Full stop. Upon consideration of the materials on record and the inspection report, the commissioner passed the impugned demolition order dated 24/7/2025. Full stop. Upon perusal of the impugned order and the records placed before this court, it is evident that the authority has acted in due compliance with the directions issued by this court in WPA number 735 of 2025. Full stop. The petitioner was duly put on notice, afforded reasonable opportunity of hearing, and the decision was preceded by a physical inspection of the site. Full stop. The inspection report clearly records that 2-storied structure has been erected on the subject premises without obtaining any sanctioned building plan from the competent authority. Full stop. Significantly, the petitioner has not been able to produce any sanctioned plan or statutory permission in support of the construction. Full stop. On the contrary, the existence of such unauthorized construction was not seriously disputed by the petitioner during the hearing before the authority concerned. Full stop. The principal contention advanced by the petitioner is that similar construction exists in the locality without any sanctioned plans, and the authorities have not taken any action against any other property. Full stop. This cannot be accepted as a valid defense in law. Full stop. It is well settled that Article 14 of the Constitution does not envisage negative equality, and illegality or irregularity in favor of one person cannot be relied upon to perpetuate a similar illegality in favor of the petitioner. Full stop. The further contention regarding payment of municipal taxes or trade license also does not in any manner legitimize an unauthorized construction raised in violation of the statutory provisions. Such act at behest indicate permissive user for limited purpose and cannot be constituted as conferring any legal right to retain an unauthorized illegal structure in absence of a sanctioned building. Insofar as the plea related to regulation is concerned, the same remains in the realm of policy and expectation, realm of policy of the government and policy of the government. Full stop. Learned counsel for the petitioner, learned counsel for the Siliguri Municipal Corporation states that the respondent number 7 also has a structure. You also have a one-story structure, right? States that the respondent number 7 also has a structure. Respondent number 7, who happens to be the neighbor of the petitioner, also has a structure existing on his plot of land. Full stop. This court directs the Commissioner, Siliguri Municipal Corporation, to conduct an on-spot inspection regarding the existence of the said structure. In the absence of a duly sanctioned plan, the authority shall take appropriate action in accordance with law after giving an opportunity of hearing to the respondent number 7. Full stop. A valid and speaking order shall also be passed as far as the respondent number 7, who has approached this court and court, and in case he does not have a valid sanction plan, the respondent municipality shall act in accordance with law. Full stop. In view of the aforesaid facts and circumstances, this court is of the considered opinion that the impugned order has been passed after due compliance with the principles of natural justice, based on objective materials and in accordance with the statutory provision governing the field, and no arbitrariness, procedural irregularity, or jurisdictional error can be demonstrated as to warrant any interference as far as the impugned order is concerned with the accordingly the present determination. Take action on his property.
My lord, since no affidavits were called for, my lord, the allegations be deemed to be denied, my lord. My lord, because
Since no affidavits have been called for.
Item number 3.
Bank time appeal.
For the petition.
Yes.
Last occasion, the honorable court of appeal was pleased to ask the bank authority to submit a report. And see the order.
Yes, you appear for the.
I'm appearing for the bank lordship.
Yes, sir.
The matter is pending before the DRT. We had already, on the last option, appraised the court that already their matter has been disposed of. The recovery postings is pending and this petition revoked that for settling their outstanding in amount. Lordship, this already this has been rejected by the bank. And why they are not approaching the DRT, it's up to them. They should approach the DRT and take steps in the recovery postings. They have given an upfront amount of 4 lakh rupees. That is also being returned.
You have to approach the DRT, sir.
Actually, we have no idea that the matter has been disposed of or not.
No.
So you are withdrawing it or are dismissing it?
Well, maybe, one may be permitted to withdraw the same.
Learned counsel for the petition takes to withdraw the present petition. The same is dismissed as withdrawn. To approach the appropriate forum in accordance with.
Grateful.
Wait, please, Your Lordship.
Item number 4.
The Ministry of Defense against the state. Here, the matter is a very short matter, Lord.
Yes.
A refund application was made within the COVID time period. And due to that COVID time period, there was a delay of a few days.
You're appearing? Ms. Rima, you're appearing?
Yes, ma'am.
So there were a few days delay in making the application, and later on, the Honorable Supreme Court had clarified that matter in the suo motu. Judgment Lordship knows better than me.
Give the dates.
Yes. And also, the department has come up with a notification instating that judgment, the judgment, and giving the data lax. Lordship will kindly see the impugned order was dated page number 46, my lord kindly sees. The last paragraph will be relevant. And there's also a coordinate benches order. I do not think I would need that. The last paragraph near place.
Yes.
The taxpayer was given notice in form so and so on 27/8/2021, disallowing the refund of so and so and to file reply in form so and so within 15 days from the date of service. The taxpayer filed reply on 29/9/2021, where he accepts that the relevant date has expired for the instant refund application and also requests to consider the and allow the refund in view of the current pandemic situation caused by COVID-19. The plea of the RTP is not considered as relevant as the relevant date of refund application has expired in the instant case, refund case under section so and so. We did central notification, RTP is found eligible for refund amount rupees D. That is the be all and end all of the case.
Is order dated 1/11.
1/11/2021.
Yes.
Lord, should I hand over the notification of the department as well? Yes.
Yes,
If Lordship kindly takes the notification, last paragraph will be important. 1(3) excludes the period from 1st day of March 2020 to the 28th day of February 2022 for computation of the period of limitation for filing refund application under 54 or 55 of the Act. This is 54 of the 55 of the Act.
yes. What is there then? If it is covered by that judgment
Yes,
and
yes.
your notification, then.
And there is also a coordinate benches order on the pat on the same work.
Actually,
Same order can be passed.
on merit, it is said my lord, it is delayed. It's a order of 2021, and my lord,
I knew this will come.
and my lord, as per rule 92 of the GST Act, my lord, it says that where the proper officer is satisfied for reason to be recorded in writing that the whole or any part of the amount claimed as refund is not admissible or is not payable to the applicant, he shall issue a notice in form GST RFB 08. Now, in this case, he was given that, my lord, and he also gave a reply to that, to the applicant, requiring him to furnish a reply, which he has given within a period of 15 days of the receipt of such notice, and after considering the reply, make an order in form GST RFB 06, sanctioning the amount of refund in whole or part, or rejecting the said refund, and the said order shall be made available to the applicant electronically. My lord, over here, the refund was rejected. The order was was given to him, my lord.
No,
But he did not go for any appeal against the said order, my lord. Under 107, he had an alternative remedy. My question is that why after 2021, after such a huge delay, in the year 2026, he has come? That is only my point, my lord. Whether after such a delay, whether this will be maintainable or not. Nothing more, my lord.
They had given me an intimation. No order was handed
This
over.
petition was also maintainable
Yes.
of 2020. Yes.
They had not given me the order. Only an intimation, a mail. And my learned friend knows, section 55, all the proceedings are offline proceedings, not online proceedings. So I got it via a mail that it has been rejected. No order was given. I made a formal application for the order. And in 2025, I got the order. December 2025, I got this 2021 order. And thereafter, I filed it before this honorable court. I had no latches on my part.
Yes.
And those are in the records. I have annexed all those documentations. Page 50, 54 will speak for themselves. Lordship kindly sees page 51. This is from Shore of the WB Comtax. Please find the attached reply. CSD March. This is the corrupt file. It couldn't have been opened. And I wanted the order. This order that I have annexed. Without that order, I couldn't have done it. And this is page 50 is my application for obtaining of the copy. And this is Minister of Defense, but why will they sleep over their rights?
Yes.
But in the year 2021, this order was passed, my lord, and it clearly says that hard copy of the same has been sent to your registered address by post, my lord.
They have never got it. If you produce, then they have been served.
My lord, I will take some time, my lord. Then kindly
Day after.
Day after, my
Lord, may I humbly submit? I have a personal difficulty. My mother is on the operation table.
Withdrawn virtue. You have already made your submission.
This is the only thing, not this.
Make a submission.
I'll kindly keep it on Friday, my lord. I'll take time to,
Lord,
my lord,
not
for
on Friday,
communication.
not on Friday, Lord,
My lord, or
because
Thursday.
Lordship,
What Friday is what?
Thursday.
Thursday is a holiday. Friday, we'll keep it on Friday.
Friday. Great, sir. I just want to concentrate and clarify it.
I'm not appointed, but that become a seasoned by Shiv.
No, my lord. I am there. I have strict instruction, my lord, not to allow such matters.
This is not any Tom, Dick and Harry. This is Ministry of Defense, my lord.
I'm grateful.
May I supply the copy of evidence of service?
Somebody used the word, she was very innocent.
You know, the innocence is best learned from the other side.
She was using that word, she was very innocent earlier, but now she's very seasoned.
That innocence can be best appreciated from the other side point of view, my lord. Service. Friday. Not today. Obliged.
Brother, affidavit.
Oh, not today.
No.
Huh? Great.
Next.
Item number 5.
My lord, I am on behalf of the petitioner. This is not complete. My lord, respondent number 2 is very much required. I have sent through the post, but not received it.
Who's on the other side?
My lord,
Who's on the other side?
other state.
Mr. Paul, you're for the state.
What is this?
Mr. Sahu,
I have to check it up. Make it on previous time.
when do you want?
My lord, 2 days is required, my lord.
Two?
My lord,
Friday.
kindly fix Friday, my lord.
Right.
Yes, my lord.
Okay.
Item number 6.
Lordship, I am for the respondent, Bhokal and Territorial Administration, Lordship.
Yes, madam.
Lordship, I'm led by Mr. Ekramul Badi, Lordship. Kindly take this matter, keep this matter next circuit. As he has fallen sick,
Fallen sick.
Lordship.
Lordship, may I submit, Lordship? This is a matter related to the voluntary teachers. Lordship, the
Oh, these
matter.
are GTA matters.
Yes, Lordship.
I'm not gonna pass it over. You call him. Every time this can't go on. Last whole week, the same answer. You please call him.
Appeal po.
This is not the last time, Lordship.
No, not last
He has
time.
fallen very sick due to the fasting for the entire month, Lordship.
Fasting for the entire month. He should appear online. This can't go on. Whole week he has wasted. And Monday I've kept all these matters, especially because on who had made this similar player. Somebody was there from your office. You were there. You have made the same prayer. I'm not going to allow this. Tell him to join online.
Fast.
Tell him to join online. What nonsense this is. Every time falling sick, falling sick. For last 1 week, we are sitting here. Yes. This is no way. The court is being more accommodating. Are you prepare the matter?
No, Lordship.
Prepare the matter. Read the file. I'll pass an order. You tell him I'll pass an order when he's not there.
Falling sick.
Ask him to join online. This can't go on like this. Last week also you stand here, you make the same submission,
आज की list है 180.
and we kept all these matters for 1 day. These are all covered matters. Ask him to join online.
Lordship, there is some change
He's
of.
fasting for 1 month, so he's fallen sick. What is this?
Lordship, this
Did the court ask him?
covered বলছে না, covered হবে
Tell him
না।
to join online.
Lordship, may I submit, Lordship?
Yes.
This matter is now not covered, Lordship.
Whatever it is, at least he should come in.
Yes.
Yes, tell me. What is there in the matter?
313 assignments was made by the GTA authority on the in the year 2019, Lordship. That appointment was set aside by Justice Viswajit Basu, Lordship. Subsequently, the GTA authority and the teachers filed an appeal. That appeal is pending before the revisions. Even the stay order was passed by the revision bench. Even the matter is running in the list in the revision bench, Lordship, today also. Item number 180, Lordship. So till the disposal of that appeal, Lordship, we cannot proceed with this matter, Lordship. In the meantime, Lordship, kindly direct us, the respondent authority, to file opposition, Lordship, 4 weeks time. In the meantime, we will file
No,
our
let him
opposition.
come first. Let him come.
Yes, Lordship.
Password. Item number 7.
7 also, Lordship, same, Lordship. Same.
Same.
8 also same.
7, 8.
7, 8.
अभी नहीं होगा.
Password.
हाँ. Ekramul Badi.
Item number 9.
My lord,
Sorry.
my lord, I am appearing in this matter, my lord, and my lord, I am praying leave to appear virtually, my lord. My lord, my
Yes.
juniors are there in the court physically, so may I start, my lord?
No, Mr. Barman wants some time.
Yes.
Half an hour, pass it over.
I'm grateful.
Item number 10.
My lords, I appear for the petition.
Yes.
And I'm led by Additional Advocate General in this matter, madam. I'm led by Additional Advocate General in this matter.
My lords, this is a penalty order which
Where
has
is it? You'll do it? You'll do. Sir,
My lord,
you'll do it, right?
yes, ma'am.
Yes.
My lords, this is a penalty order which I have challenged without going to the appellate
Why?
forum. Lords, on two grounds. First is on the excess of, this is a case of excess of jurisdiction, and secondly on the count of violation of natural justice. Firstly, my lords, I am a transporter. These invoices were issued by Maruti Suzuki Private Limited, my lords, India Limited. They had supplied some 8 cars to a registered dealer in Assam. The goods were being transported. On the New Year day, that is 1st January 2026, the car had a breakdown in, the truck had a breakdown in Siliguri. The only default committed was that under the GST Act, if the vehicle is changed, they have to update Part B of the e-way bill. That was not done. Car was intercepted after some time, and within 13 minutes of the interception, the new e-way bill was also generated, the updated e-way bill. Now, they have imposed a penalty of 13 lakhs, which I paid and released the goods because there was huge cost involved. And so, my lords, this is a case, and they had also done the physical inspection of the goods. Nothing, no mismatch was found. Still, my lords, they imposed this 129 penalty. The show cause notice is dated. The show cause notice provided me time till 7th, and they had passed the order on the same day, on the premise that I have already paid for the release of the goods. That's why I have admitted my liability. This question had been answered by the Supreme Court in a recent judgment, which I will place, my lords, where Supreme Court has clearly said that merely making payment will not suffice. Opportunity has to be granted to them.
Go before the appellate authority.
Yes.
My lords, but this is, no, in the Supreme Court's case, my lords,
Sir,
on the same factual facts, my lords, the High Court had not entertained, matter went up to the Supreme Court. Supreme Court said that no opportunity has to be granted. On the same self facts, my lords.
this also you take it to Supreme.
And this is a Supreme Court judgment on a very similar fact.
No.
This also take it to Supreme Court, both of you.
Kindly, my lords, kindly just bear with me. Just I'll show one.
There was
two
no order
paragraphs
passed
from-
in that case because they have paid the amount.
No, here also.
They have paid the
Kindly
amount, so
see-
the adjudication order was not passed.
Para
in this
14
case.
onwards.
Was this 2025?
My lords? Yes, 2025. July 24th, 2025. Para 14 onwards.
Order was not passed.
19 onwards is the
14 clearly says so.
Internal page?
internal pages, second last page. 21. Kindly take paragraph 19 onwards.
Different facts.
Now, let's kindly take page number 75 of my petition. This is part of the show cause notice. '75 is the last page of the show cause notice. My lords will see, I have been asked to appear before the undersigned on 7/1/2026, and it is dated 1st 4/1/2026. The digital, page number 67, it starts. The last page it has, is at 75.
You're appear on 7/1.
Yes. And Milords, now come to page number 80, which is the final order. Operative part is at 88. The last part, Milords. On the same day, they passed this order, Milords.
So what is the difficulty they pass the order?
Milords, I had made the payment prior to this date. Kindly appreciate, Milords. On 3rd, I make the payment. On 4th, they issue me a show cause notice asking me to appear on 7th. On 4th itself, they pass this order. I should be granted an opportunity of hearing, Milords. This is
Go
a,
before the authority, they'll give you an opportunity of hearing. They'll give a direction. They'll give a direction, they'll give you an opportunity of hearing. What is the difficulty?
and my lords, I am covered by my lord's order also, Milords. In one case, my lords had admitted this writ petition where there was no intention to evade tax.
Correct. Not here.
As my lords decides.
Yes, Ms. Reema.
My lord. First, my lord, the Supreme Court judgment on which I rely, my lord, it's a very similar sort of case, my lord. The respondent is a proprietary concern engaged in the business
Which
of
paragraph?
para 3, my lord. Second page.
Yes.
Is a business of iron and steel and is registered under the central GST and has been allotted a GST code. The respondent purchased certain goods from a dealer under a tax invoice dated such and such. The consignment of goods was being carried in a truck bearing registration number such and where it was proceeding from the state of Karnataka. It was intercepted on 12/12/2019 at 5:30 and the tax invoice indicated the goods were earmarked for delivery at Balanagar, Telangana. The case of the appellant is that Balanagar is situated between, it's a similar sort of fact under 129. The penalty was imposed. And my lord, over here in para number 10 of this judgment, my lord, it says that the respondent had a statutory remedy under section 107. Instead of availing of the remedy, respondent instituted a petition under 226. The existence of an alternative remedy is not an absolute bar to the maintainability of a writ petition under Article 226 of the Constitution, but a writ petition can be entertained in exceptional circumstances where there is a breach of fundamental right, violation of principle of natural justice, and excess of jurisdiction, a challenge to the virus of the statute. In the present case, none of the above exception was established. There was in fact no violation of principle of natural justice since a notice was served on the person in charge of the conveyance. In this way, it was not appropriate for the High Court to entertain a writ petition.
I am also relying on the same judgment. This is Assistant Commissioner. Commissioner Steels.
No, commercial state.
Hey, I am also relying on that judgment.
Very good.
Para 11.
Relegated to the state on the petition has preferred the present writ petition, challenging the notice dated. What is the date of this?
Oh, date of penalty order, my lords?
Penalty order.
4/1.
4/1. Challenge the impugn order dated 4/1/2026 passed by.
Stock dates
Passed under section 129(3) of the Central Goods and Service Tax Act 2017 and West Bengal Goods and Service Tax 2017, whereby a penalty of rupees 1,358,844 has been imposed upon the petitioner. This passed under 129(1) or
3.
129(3), right? Learned counsel for the petitioner submits. Learned counsel for the petitioner, Mr. Dheeraj Lakhotia, submits that the vehicle carrying the motor cars supplied by Maruti Suzuki India to its registered dealer in Assam was intercepted at Alipur Dwar on 1/1/2026. Full stop. It is further submitted that due to breakdown of the original vehicle near Siliguri, the goods were shifted to a replacement vehicle. Full stop. Learned counsel submits that upon interception of the said vehicle, all documents were produced and consolidated e-way bill in respect of the replacement vehicle was also generated immediately. Full stop. He further submits that upon physical verification of the goods, the same were found to be totally matching with the invoices and no discrepancy in respect of the goods were found. Full stop. However, the respondent authority issued a show cause notice. What is the date of the show cause notice?
4/1/2026.
Issued a show cause notice and passed the impugn order dated 4/1/2026, whereby imposing the aforesaid penalty upon the petitioner. Full stop. Learned counsel for the petitioner states that the said order has been passed in violation of the principles of natural justice. Full stop. It is further submitted that the penalty was paid under protest and the same cannot be assumed to be securing, and the same cannot be assumed as the accepted guilt or fault on part of the petitioner. Full stop. Learned counsel for the respondent states that the present order is an appealable order under section 107. Right?
Yes,
107.
Is an appealable order under section 107. Full stop. She states that the petitioner has alternative efficacious remedy available in law. Full stop. This court has considered the submissions advanced on behalf of the parties and has perused the materials on record. Full stop. The impugn order has been passed under section 129(3) of the aforesaid act. Full stop. And efficacious statutory remedy of appeal is available to the petitioner under section 107 of the said act against the order passed by the proper officer. Full stop. It is well settled that when a statutory remedy of appeal is available, the writ court ordinarily refrains from exercising its jurisdiction under 226 of the Constitution of India unless exceptional circumstances are made out, having regard to the facts and circumstances of the present case, and without entering into the merit of the controversy, this court is of the view that the petitioner ought to avail the statutory remedy of appeal before the appropriate authority under section 107 of the act. Full stop. In the event such appeal is filed within a period of 2 weeks.
4 weeks, 2 weeks, yes.
2 weeks from date, the appellate authority shall consider and decide the same on its own merit and in accordance with law, without influence by any of the observations made by this court. With the aforesaid direction, the present petition stands disposed.
Grateful.
Item number 11.
My lord, I am for the petitioner in item number 11. This is my affidavit of service, my lord.
I am for the respondent, Gorkha Territorial Administration.
My lord, these petitioners were appointed as volunteer teachers in the schools situated under the administrative control of Gorkhaland Territorial Administration, my lord. After the promulgation of the Gorkhaland Territorial Administration Act, my lord, the appointment relating to the educational institution has been vested upon the Gorkhaland Territorial Administration, my lord. And the process of appointment of teachers in state aided schools has not been given effect into the jurisdiction of Gorkhaland Territorial Administration, my lord. So accordingly, these petitioners have made representations, and these petitioners get to know that there are certain judgments passed by the honorable division benches. By virtue of that, similarly situated teachers were given appointment, my lord. These were the fact. However, there is a change in circumstances, my lord. Similarly situated teachers, their job has been challenged before the writ court, my lord, and subsequently, when the writ court when the writ court allowed that petition, Gorkhaland Territorial Administration has filed one appeal against that judgment, my lord. That is pending, and a stay has been given upon that order, my lord. So I have filed this matter, and I'm praying that with that outcome of that appeal, my lord, let my with the same my matter be disposed of, my lord.
We'll await the outcome of the MET appeal.
And though, my lord, there are certain judgments.
Same lordship, in that order, lordship, there is a petition to not to pass any further orders, lordship. Lordship, 120 matters were filed regarding the same issue. In the similar matter, lordship, there is a direction upon the respondent authority to file opposition. Lordship, kindly pass the same order so that can.
You have the order?
Yes, lordship, I'm giving.
There is a stay, my lord.
Stay na.
There is a stay upon the outcome of the writ petition, my lord.
Amrita Sinha order to then. Lordship, kindly pass it over. I'm giving lordship.
You have Justice Sinha's order? Last, she has passed some orders.
My lord, I need to check that, my lord. 11, 12, 13, same matter, my lord.
You should get the order, madam.
Yes, lordship. My mistake, lordship. Policy, lordship.
Awesome.
Lordship, I joined today, lordship.
I didn't see you last.
Yes, lordship.
Pass over.
I was sick, lordship.
14,
I was hospitalized.
Pass over. 14 okay now?
14th.
You,
Lordship, 14th is then filed.
pass over or tomorrow? What do you want?
Lordship, 14th is a group C staff. That is not for the teaching staff.
Yes, my lord.
So, lordship, kindly keep this matter also pending, lordship, because
No, there is
no direction, but we won't proceed further, lordship, till the disposal of the matter.
no, my lord. That's not the case.
File your reply.
My lord, may I proceed with the merit of this matter, my lord? Item number 14. This is my.
We'll have it tomorrow. You get all this, the orders which have been passed.
Okay.
Tomorrow we'll have it.
Lordship, if pass it over, I can give lordship at 2 p.m.
Tomorrow we'll have it.
Yes.
Tomorrow we'll have it. Not today, tomorrow.
Okay.
You are here only.
Yes, my lord.
Item 14th out, right?
हाँ, same.
14. 13.
देखो. 13, 14, right? 13, 14.
13, 14, my lord. 16,
11, 14.
11, 12, 13, 14. There are
11, 12, 13, 14.
11.
16, 17, 16, 17, 19, 20, 21, 25, and 26.
Have all of them tomorrow.
Yes.
Just give the numbers.
I have submitted one affidavit of service, my lord. May I get it back?
Give it. Give the affidavit of service back.
কাগজ আছে এখানে কাগজ তো চিরকুটটা দাও না ওখান থেকে
These are all your matters, right?
Yes, my lord.
Only that group C is a different one.
Group C is a different
Otherwise,
one.
all
others are same, my lord.
6, 7, 11, 12 also the same. But
Just give the numbers.
Number 15টা.
You give the numbers. You are.
Yes, yes, my lord. I'm writing it.
Item number 15.
My lord, item number 15, I am for the petitioner. My lord, this is a transfer of an assistant school teacher in secondary level. My lord, NOC already accorded by the school authority, and my lord, last occasion disposed of one matter. Similarly, circumstances, if you my learned junior is there, handing over the copy of that order. If your lordship, so my lord.
My lord, I am
Similarly-
appearing on behalf of the Central School Service Commission, my lord. Last occasion, your lordship
Yes.
rejected the my lord, district school authority to forward the issue to the district inspector of school, and district inspector of school was directed to my lord consider accordingly.
Yes. Mr. Law Scholar, kindly forward the.
Yes, yes, yeah.
judgment namas.
Yes, yes, to the DI, I am representing the state. It may be sent to the DI. Considered.
But school authority already issued the NOC. But similar fashion, but your lordship disposed of one similar matter.
Same order.
Yes.
Grateful, madam.
Item number 18. 17 এর ভিতরে না না
Who's there? 18. Not today. ये clients में 18 में कर रहे हैं ना? None for the petition. In the interest of justice, adverse orders are deferred. Let this matter be listed on Friday.
Friday.
Wednesday कल.
Wednesday. Twenty 86, 87.
All the GTA matters. सारे date लगाए ना?
My lord, I appear on behalf of the petitioner 678.
Mr. Bari, on your name only we have been giving date.
No, my lord, I'm extremely sorry. Kindly excuse me. My advocate record could not come to the court due to his illness. That's why, my lord, the information was given to me that adjournment will be short for. That's why I couldn't appear. I was in a
last.
Anyhow, my
last
lord,
week also we have been. We have kept all these matters for Monday now or Tuesday tomorrow.
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 Very well.
দেখছি
678 same matter.
678 also tomorrow. 678.
24. There, 24 হলো 394 না না 21 তোর ভেতরে 24 হবে 22 380 22 item number 22.
This is the matter which was heard. It's the matter of 16.4, the GST matter, where an order of 16.4 was passed. Subsequently, the 16.4 was amended and 16.5 came into force. Now they have proceeded with the proceedings and have recovered money also on the basis of the 16.4 order. And that my humble prayer is it can be sent back so that they give me the benefit of 16.5 and pass a fresh order.
Yes, madam.
My lord, I'm led by Additional Advocate General in this matter, my lord. He's on his way, my lord.
Recording appearance.
My lord,
It's a very topmost prayer since the legislature has already inserted 16.5
There's a limitation period for the same, my lord, to file that application, my lord. My lord, they have not annexed the notification.
Yes.
My lord, the notification has given a date for a period of 6 months. From, my lord, the date, the notification is 8th October 2024, my lord. My lord, I am just handing over a copy, my lord. My file is just, my lord, I have a.
This period files, he has filed his tax on 19/11/2020. The extended period is till 30/11/2021.
Yes. No, my lord, no. My lord, just a second, my lord. In my file, I have taken a note. But just a second.
That I've relied upon a judgment which I had
There's
submitted.
a judgment here also of SD Enterprise.
Yes, ma'am. That in this matter also, this is in 2025, the order was passed, where it was sent back so that they can give me the benefit and pass a fresh order. And then there is one more judgment of a coordinate bench on the similar ground.
Yes, my lord. My lord, kindly see.
Give the order.
Order.
The only thing which needs to be seen whether it falls within that period.
Yes, yes. That my lord, I am just showing. My lord, sorry, my lord. Kindly see if the order, then I will.
Like the same thing, it has been remanded back so that the proper officer can adjudicate whether I fall within the period and pass this effective order.
Give a copy of the order.
I have to provide them.
কোথায় এটা দিস কবে ফাইল করেছো বল ডেটটা বল 5/6/20.
Yes.
Yes. My lord, the notice 14th May 2024. Then my lord, the adjudication order 22nd August 2024.
Yes.
And my lord, this in adjudication order, it said that 16(4) violation. Then my lord, the notification has come, my lord. My lord, may I hand over?
Notification has come much later,
Yes.
but with the retrospective.
Retrospective effect, right. My lord, notification in 8th October 2024.
Yes.
With the retrospective effect, my lord, kindly read, my lord, paragraph 2 of that notification. The said person shall file electronically or on the common portal within a period of 6 months from the date of issuance of this notification. So, my lord, this notification has come 8th October 2024. So, within 6 months, it coming, my lord, 8/4/2025. So, within 8 April 2025, they ought to have filed. They filed on 5th June 2025. And accordingly, it has been rejected. That is a barred by limitation. And the writ petition filed on 27th February 2026. They haven't preferred an appeal challenging that order of 5th June 2025. Now they have by filing writ application saying that we will go back to the appellate authority.
Yes.
My lord, in this matter, there are two parts. My lord, one, my lord, this section was imposed on from 27 September 2024 for the Finance Act 2024. My lord, this Finance Act, it got a presidential assent when it became an act from Finance Bill in the month of August before passing the order.
What he's saying is that the rectification application should have been filed within 6 months.
My lord, admittedly, we filed it. My lord, just because a notification cannot block me from availing a credit which is I am liable to get by the statute itself. My lord, even in the judgments I have referred, we have come after without filing the rectification. My lord, my humble prayer is that if the statute provides me some relief, can a notification block me from getting it? My lord, because it's a retrospective amendment. It's not that it's a prospective amendment. And I fall within the date of this 30th of November 2021. My lord, my humble prayer at the time of passing order, the adjudicating authority was aware of this notification, aware of this section to be amended. They could have changed it. Even they have the suo motu power to rectify an order if it is apparent for record. My humble prayer is let it be sent back because that is a credit I'm legibly allowed by the amendment.
Let them file it. The petitioner has preferred the present petition challenging the ex parte order.
My lord, I came in late because they have now recovered money from my
I'm not dismissing it.
Yes, ma'am.
I'm not dismissing it.
My lord, my prayer is that they have recovered the money also now. The entire amount they have recovered.
They have recovered.
Yes, ma'am.
That's all right, Sam. Let them file their reply. I'm not relegating you back without getting their affidavit. Learned counsel for the petition preferred the present petition challenging the ex parte adjudication. Order dated 22/8/2024 passed under section 73 of the Central Goods and Service Tax Act 2017, whereby the input tax credit pertaining to the financial year 2018-19.
The financial year
18-19 was disallowed under section 16(4).
Financial year 19-20.
19-20 was disallowed under section 16(4) of the said act on the ground that the return in the form GSTR 3B for the month of March 2020 had been filed beyond the prescribed statutory time limit. Learned counsel for the petitioner submits that the list show cause notice dated 14/5/2024 was issued by the respondent alleging the wrongful availment of input tax credit. Full stop. The allegation of the respondent proceeded on the basis that the return for the month of March 2020 was filed on 19/11/2020, whereas the unamended provision of section 16(4), the last date of availing such credit was treated as 20/10/2020, and therefore the credit was alleged to be time barred. The petitioner failed to file reply to the said show cause notice, and hence the adjudication order was passed on 22/8/2024, wherein the respondent full stop. Learned counsel appearing for the petitioner submits that the legislature subsequently inserted section 16(5) into the GST Act, thereby statutorily validating the input tax credit for the relevant year where the returns were furnished up to 3011, right?
Yes, 3011,
2021. Yes, full stop. Learned counsel for the petitioner submits that he had filed his return on 19/11/2020, which falls well within the statutory extended period. Full stop. Accordingly, learned counsel submits that the very foundation of the impugned adjudication order no longer survives in view of the statutory amendment. Full stop. Learned counsel appearing for the petitioner further submits that due to bona fide reasons, the petitioner could not participate in the adjudication proceedings, resulting in the impugned order being passed ex parte, as no personal hearing was afforded to him.
Well, they have participated, Mullah.
Ex parte.
Ex parte, but they have participated on the very first two occasions.
The final.
Final.
At the relevant point of time, the petitioner admits that at the relevant point of time when the adjudication order was passed, the return was beyond the statutory period, and therefore the petitioner did not challenge the adjudication order. Full stop. However, subsequently to the amendment of the GST Act, introducing the 16(5), the petitioner's return now falls well within the statutory relaxed period, thereby rendering the basis of the impugned order unsustainable. Full stop. In such circumstances, the petitioner has approached this court. Full stop. Learned counsel appearing for the respondent. You want to file your reply?
Yes.
Seeks and is granted 2 weeks time to file affidavit in opposition.
No further recovery till they have completed it.
What further recovery? That is only for that period.
No, they have started recovering the amount as per demand of 16(4). They have started recovering. Some part has been recovered. A stay may be given till the disposal.
No, my lord, no, my lord. If any recovery
is that?
My lord, I have mentioned, my lord, the recovery amount is attached in page number 24. 24, my lord, of the petition. My lord, 24 onwards, my lord, the liability ledger they have recovered against the demand. My lord, 24 is the IGST amount, 25 is the CGST amount, 26 is the SGST amount.
You don't recover any amount.
Milord?
This is not done. The recovery should not be done.
Milord, the page 24, my lord, kindly see.
Yes.
Page 24, my lord, this is the electronic. It's a ledger, my lord.
My lord, that's where the amount the credit.
Electronic liability ledger. Where the recovery?
On the third column, my lord, point number 4.
Liability.
Yes, my lord, it has been recovered. Amount recovered against demand. My lord, number 4.
Amount recovered for that particular period.
That demand number.
But only for that period has been recovered.
My lord, the demand.
How can they raise subsequent?
No, I cannot.
My lord, they have recovered the amount. They have started recovering because the demand is high. They are partly recovering the money over a period of time because this is on 30th May for this demand order of 16(4). Then recovered some on 31st December, then some in 22nd August. My lord, they are recovering part wise of the total demand of 16.
Yes, total demand for the particular period.
My lord, the whole amount has not been recovered. There some parts have been recovered. They will again start recovering money. If
Yes, for the particular period, my lord.
Recovered.
It is in the order.
My lord, if my lord kindly see they have not availed or not approached, my lord, then the proceedings should be initiated and the recovery proceedings, my lord, cannot be stalled.
That should be stayed.
The section is no longer existent.
How much is the total amount?
My lord, the total demand is, well, along with interest and payable is 6,94,000.
How much you have paid?
My lord, they have recovered around 3.5 lakhs.
Well, any my lord, this wrong or anything, my lord, jeoparding the petitioner, nothing has done. Within the scope and ambit of that, my lord. As my lord, we have started recovering, then only he woke up, my lord, and approached to this honorable court.
He is entitled to that relief of 16(5).
No, the 16(5), my lord, that's true. The 16(5), if he has chosen not to file in an appropriate time.
I'm just allowing you to file this, otherwise I would have set this aside. Let me tell you very clearly. The act is very clear. It has been extended till 2021. He has filed it within time. There is no question that you can recover anything from him.
Well, the
Only reason why I'm not passing an order is because I'm allowing you to file your affidavit so that this issue can be put to end. Otherwise, I would have not even allowed you to file your reply.
But yes, my lord, but my lord,
Because I don't go by your reading that it has to be passed within 6 months. He has to prefer that. If a statute has given a relief to a person, he's entitled for that.
but the, my lord,
Whether he comes after 6 months or he comes after 5 years.
but the notification, my lord, I
The
understand the
notification
notification.
itself has given him the relief.
My lord, notification, my lord, with
The
respect to-
only reason not passing an order is because I'm letting you file an affidavit.
No, all right.
So that I'll put this to end.
No, Lord. We'll, my lord, that would be.
Otherwise, there is no question of recovery. No question of illegal recovery. Learned counsel for the respondent seeks and is granted 2 weeks time to file affidavit and opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks before the next available circumstance. In the meantime, the recovery proceeding shall remain stayed for a period of 8 weeks or until further order, whichever is earlier.
Yes, Lord.
He is entitled.
Well, in
completely
the
entitled.
well, statute says,
Just because you made an argument of 6 months, I'm allowing you to file an
my
affidavit.
lord, it is.
Otherwise,
I
this
am.
goes.
My lord, I
Order
understand. Below the notification and the statute.
The
Statute cannot.
notification itself contrary to the statute.
My lord, yes, that's.
Your notification will also go.
If it is challenged, the notification ought to have gone.
Absolutely. Can't, by way of a notification, you will.
I cannot stall by a notification. Statute will override.
I'm not saying anything. If you want me, I'll decide this right now. I'll set aside your notification also.
Well, in 32, they have challenged.
Stay there.
You
will win at the
Even
end
the
of it.
notifications are under challenge. And the honorable court has passed the order staying all the recovery proceedings in my matter only. Since your lordship was passing an order, I did not intervene. Well,
Obviously, you have to stay.
wait,
This is illegal recovery. He'll be.
truly, there are not one, my lord. There are 4 notifications. 2 of the state, 2 of the centre. And the hilarious part is the state government has brought out the notification on 25th of February and given it effect, made it at tandem with the central notification. That is 8th of October. There are thousands of lacunae in this matter.
Well, as there is a lacuna, that's why they are approaching the court matter. Otherwise, what happens?
And taking your hospitality. Grateful.
Lordship, item number 18, Lordship, both sides are present, Lordship. At that time, Lordship, the display board, Lordship, showing item number 10 for that reason.
We'll have it tomorrow.
No. Item number
18. Both sides are present, Lordship.
Wednesday. Wednesday will have.
18.
Wednesday. What is the difficulty? We'll have it on Wednesday.
Not today.
Not today.
item number 23.
Yes.
Petitioner was a school teacher, my lord. She seeking transfer. She made several, my lord, representation to the authority, my lord.
My lord, I am
There-
appearing on behalf of the Central School Service Commission. My lord, though my lord, the commission has received the copy of the petition, my lord, I have not received, my lord. So that I am only visiting before your lordship, take up the matter day after tomorrow.
Hilal,
If your lordship
Mr. Hilal,
my
I have not
lord,
given a
my lord,
copy.
kindly check. Yes.
Sorry,
Malad.
Mr.
My lord, though the commission has received the brief, my lord, the writ petitioner has, my lord, served upon the commission. My lord, I have not received the copy from the commission, my lord. It's my difficulty, my lord. Writ petitioner, there is no fault on the part of the writ petitioner, my lord.
All right. So we'll have it. When do you want, Mr.
A day after tomorrow, my lord, if your lordship can, my lord.
Day after. And who's appearing for the state?
Yes, yes.
You're appearing for- Who has to take an action? Director school?
Yes, ma'am. Commission.
Mr. Kumar, you have to take a decision on
Yes,
the
ma'am.
application.
Yes, ma'am.
My lord, the petitioner has to make an application before the school authority. So, my lord, kindly check it up.
School
If the
will-
lordship wants to dispose it of, my lord, kindly check that whether the petitioner has made any application in prescribed format before the school authority or not. If, my lord, he has not filed any application in prescribed format, so, my lord, kindly give liberty to the petitioner to make a fresh application in prescribed format. Representation.
They have to apply fresh.
Mr. Ilal,
Yes,
you have
ma'am.
made an application.
I made, my lord,
No, application has been made to the commissioner. They have to
My lord,
first apprise the
this is not the
school.
It must be before the school authority and it
Liberty.
must be in the school.
Even liberty. I went to the, my lord,
Learned
kindly,
counsel for the petitioner seeks to withdraw the present
my lord,
petition
kindly,
with
1 minute
liberty.
before we tell, my
With
lord,
liberty.
my lord, 1 minute, my lord. I went to the school, my lord, and they're not receiving, my lord. Page
Okay, you-
29 is not,
Post.
Not receiving, you do it by post.
My
Mr. Ilal.
page 29 is my detailed representation, my lord, for this reason, my lord.
My lord, representation is not enough, my lord. My lord, rule provides a format, prescribed format, and
Find it
honorable.
according. Yes. Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings with better material particulars. Liberty is granted to the petitioner to file appropriate proceedings in accordance.
My lord,
Grateful, my lord.
My lord, item number 9 was passed over. Mr. Bonik is here, my lord. It can be taken up.
Yes.
Item number 9.
My lord, I am appearing in
Yes.
this, my lord, on behalf of the petitioner, my lord, and I pray your
Yes.
lordship's leave to allow me to appear virtually, my lord, because I'm out of the state. So, my lord, may I proceed, my lord? My lord, in
Yes,
this
yes.
writ petition, my lord, I have challenged the adjudication order passed by the GST authorities under section 74 of the CGST, Central Goods and Services Tax Act 2007. My lord, I have challenged this on the ground that the show cause notice is without jurisdiction. There has been a gross violation of the principles of natural justice, and the adjudication order has been passed for multiple years, my lord, which is also not in accordance with law and without jurisdiction. They have not followed the due process of law, and also the circular number 31/5 dated 9/18, whereby authority has been given to the investigating wing to issue the show cause notice. Now, my lord, before I go to the points of law, my lord, let me briefly state the facts of the case on which the law hinges. Now, my lord, what happened? A search and seizure was made on 10/8/2018 at the petitioner's place of business. And my lord, during the search and seizure, they found documents showing that I have made purchases from certain suppliers, which is, my lord, recorded in my returns. And I have claimed ITC. And my lord, in course of search and seizure, my lord, they seized 75 lakhs of rupees, which is also not permissible under the act. And my lord, they also forced me to pay 25 lakhs of rupees under coercion. My lord, I am not on this because I have challenged the search and seizure before this court, my lord, in a separate writ petition, which is ready for hearing. My lord, I'm only giving the background of it, but I am not passing this before this now. Now, my lord, and only one point I would like to mention here, my lord, the money which was seized during the search, they have appropriated it. That is 75 lakhs, which they are supposed to return it to me once the adjudication proceedings start. But be that as it may, now, my lord, arising out of that search and seizure, a show cause notice under section 74 was issued by the investigating authority, that is the DGGI. Now, my lord, when they issued the show cause notice, they relied upon certain documents on which adverse comments had been made against me by a transporter and by a broker, saying that goods were not supplied to me. But those, my lord, those relied upon documents were never given to me. So I filed a writ petition, my lord, challenging that show cause notice, although I made several requests to them that please give me the relied upon documents. They did not give it to me, my lord. Then the single bench, the learned single bench, my lord, by an order dated 37/2025, relegated me and said you prefer an appeal, despite my submission that there was a violation of principles of natural justice. My lord, against this, the petitioner preferred an appeal before the division bench of this court, and the division bench, my lord, by a judgment dated 8/9/2025, my lord, which is at pages 249 to 255, set aside the order of this learned single judge and also the adjudication order and directed them to file, to serve me the relied upon documents. And my lord, in that judgment, the court held that there is no evidence to show that the relied upon documents were given to me, and that although I made several prayers before the authority, still the authority did not give me those documents. My lord, thereafter, the authority gave me, my lord, provided me the relied upon documents. My lord, and after getting the relied upon documents, I submitted a detailed reply. In this reply, my lord, kindly, in my addendum to the reply, which is at page 367 to 369, I challenged the jurisdiction of the DGGI, that is the investigation wing, to issue me a show cause notice. My lord, I will place the relevant law. My second point was that you have said that these are relying upon the statements of these people who have made adverse comments against me. I would like to cross-examine them. Please allow me to cross-examine them. I also said that you cannot, they passed, my lord, for 1718 and 1819. It was stated that you cannot club multiple years in one show cause notice, and I relied upon a judgment of a division bench judgment of the Kerala High Court. My lord, the authorities did not, the respondent who passed the adjudicating order, she, my lord, did not deal with my prayer for cross-examination, did not, my lord, consider that when I said that the DGGI has no authority, is not vested with the authority to issue me with the show cause notice, did not deal with it. They relied upon a document of a judgment of Bombay High Court stating that, yes, they have the power to issue show cause for multiple years, but that judgment has been overruled by a subsequent judgment of the Bombay High Court. Now, my lord, and now I will place, my lord, the law. Now, my lord, the first thing is, my lord, kindly see the show cause notice has been issued by the Director General, which is at, my lord, page, my lord, the show cause notice is at page, my lord, kindly, probably, my lord, 256. 256.
And it should be 254.
My lord, 254. It starts from 254, my lord, demand come show cause notice, and my lord, it ends at my lord, kindly bear with me, my lord. It's a huge, voluminous. My lord, kindly see, my lord, at page 332. That is, he is the additional director, my lord, of the investigation wing. That is Borough.
332.
What is the authority on the basis of which they are issuing the show cause notice, my lord? It is on the basis of a circular. But before I come to the circular, my lord, may I present before your lordship, place before your lordship, section 74 of the Act. My lord, has section 74 of the CGST Act, my lord?
Yes.
My lord, has it?
Yes, madam.
Yes, ma'am. My lord, I'm reading it out. My lord, 74 says determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or willful misstatement. My lord, it starts with this where it appears to the proper officer that any tax has not been paid, my lord, or whatever is written or short paid or erroneously refunded, my lord, or has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve a notice on the person chargeable with tax which has not been paid, etc., etc. So, my lord, who will issue me the show cause notice? The proper officer. Then, my lord, that is 2. The proper officer shall issue the notice under subsection 1 at least 6 months prior to the time limit specified in subsection 10 for issuance of an order. Then, my lord, comes what procedure he has to follow. 3 says that he will serve a statement. The proper officer will serve a statement containing the details of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for such periods. Then, my lord, subsection 4, the service of statement under subsection 3 shall be deemed to be a service of notice under subsection 1 of section 73. Means, my lord, even under section 73, this will be a notice. Then, my lord, subsection 5, the person chargeable with tax may, before service of notice under subsection 1, pay the amount of tax along with interest payable, and under subsection 50 and a penalty equivalent to 15% of tax on the basis of his own ascertainment of such tax or the tax as ascertained by the proper officer, and inform the proper officer in writing of such payment. That is, my lord, the person who issues the show cause notice. Then the proper officer on receipt of such information shall not serve any notice under subsection 1 in respect of the tax so paid or any penalty payable under the provisions of this act or the rules made thereunder. Then, my lord, where subsection 7, where the proper officer is of the opinion that the amount paid under subsection 5 falls short of the amount actually payable, he shall proceed to issue the notice as provided for in subsection 1 in respect of such amount which falls short of the amount actually payable. Then, my lord, I'm skipping 8 because it is only a procedural part. Now, my lord, the relevant provision is subsection 9. The proper officer shall, after considering the representation, if any, made by the person chargeable with tax, determine the amount of tax, interest, and penalty due from such person and issue an order. So, my lord, it is the person who passes the order is vested with the authority or the right to issue a show cause notice to me. The taxpayer files his objection before the proper officer, and the proper officer, after considering the reply, passes the order. Now, my lord, kindly see on what basis they have, that is the investigation wing, the DGGI has issued me a show cause notice. My lord, that it is on the basis of a circular, my lord, which is at page 510. My lord, I'm 510. My lord, I'm reading out, my lord, 510, what the circular says. It says, my lord, it is a circular, my lord, if your lordship sees, the board-wide circular number such and such assign proper officers for provisions relating to registration and composition levy under the Central Goods and Services Tax Act. My lord, that is in respect to, it says that who will levy taxes and the rules made thereunder. Further, wide circular number such and such, the proper officers for the provisions other than registration and composition under the GST Act were assigned. In the later circular, the deputy or assistant commissioner of central tax was assigned as the proper officer under subsection 1, 2, 3, 5, 6, 7, 9, and 10 of section 74. while the superintendent of central tax was assigned as the proper officer under subsection 1, 2, 3, 5, 6, 7, 9, and of section 73. So for my lord, for section 74, a proper officer has already been assigned the job whose duty is also to issue a notice under section 1 and all subsection 1 of section 74 and also pass an order under subsection 9 of section 74. Now, my lord, what they have done, they are stating that it has now been decided by the board that superintendent of central tax shall also be empowered to issue show cause notice and orders under section 74 of the CGST Act. Accordingly, the following entry is hereby added to the item at serial number 4 of tables on page number 3 of circular number such and such, namely, my lord, that is superintendent of central tax, etc. Then, my lord, further in light of subsection 2 of section 5 of the CGST Act, whereby an officer of central tax may exercise the powers and discharge the duties conferred or imposed under the CGST Act on any other officer of central tax who is subordinate to him, the following entry is hereby removed from the table. So this entry, my lord, is removed. In other words, all officers up to the rank of additional joint commissioner of central tax are assigned as the proper officer for issuance of show cause notice and orders under subsection 1 to, my lord, subsection 10 of section 73 and 74. So, my lord, under subsection 73 and 74, there are proper officers for each jurisdiction. My lord, somebody in this Jalpaiguri jurisdiction will have a proper officer assigned. Somebody, my lord, in, let us say, Howrah jurisdiction will have a different proper officer. And it will be seen from this that the proper officers are to issue notices under section 1 as well as under section 10, section 9. Now, my lord, they give the pecuniary jurisdiction. That is, my lord, paragraph 5 is the pecuniary jurisdiction of the proper office. My lord, I am not on that. Now, my lord, I have come to section 6, which I've challenged. They say the central tax officers of audit commissionerates. My lord, audit commissionerate is not applicable to me. And Directorate General of Goods and Services Tax Intelligence, hereinafter referred to as the DGG-SIT, shall exercise the powers only to issue show cause notices. A show cause notice issued by them shall be adjudicated by the competent central tax officer of the executive commissionerate in whose jurisdiction the notice is registered. Now, here I'm saying, my lord, this is in derogation of section 74, which says that the proper officer, that means who is the jurisdictional officer in that executive commissionerate, he issues the notice under section 71, that is the show cause notice, and he adjudicates and passes the order under section 9. And the taxpayer to whom the notice has been given files his representation before the proper officer who issues the show cause notice. Now, by this notice, what they did, they have carved out an exception, and they have said that the Directorate General of Goods and Services Tax will issue the show cause notice, but though he is not the proper officer for this, but the actual adjudicating officer will adjudicate the matter. Now, my respectful submission before your lordship in this matter is that who is the proper officer? The person who is adjudicating the notice is the proper officer to issue me a show cause notice, which will be apparent from the statute and also from what they have stated earlier. Now, my lord, I will state that what has happened, what was my reply in my lord. I'm tracing my reply, my lord. My lord, kindly come to page 367 to 369. My lord, I have specifically raised this issue before the authority who issued the show cause notice. My lord, kindly to read, my lord. My lord, may I read my reply?
Yes, yes.
My lord, I have written that we had filed a reply dated such and such, and you have fixed a virtual hearing of such and such. While we will appear in the said hearing through our advocate, we would like to submit an addendum to a reply dated 22/9/25 to the above. It is submitted that the show cause notice dated has been issued by the additional director of the Directorate General of GST Intelligence, who is not the proper officer in the instant case. My lord, I quoted section 74 and I quoted subsection 9. My lord, I'm skipping what I've quoted. Subsection 9 of section 74 provides that the proper officer shall, after considering the representation, if any, made by the person chargeable with tax, determine the amount of tax, interest, and penalty due from such person and issue. It will be abundantly clear from the above provision that the proper officer is the adjudicating authority who is vested with the power under section 74 to issue a show cause notice on the basis of his satisfaction. Since you are the adjudicating officer and the proper officer, the show cause notice ought to have been issued by you on the basis of your satisfaction and not by the additional director of the Directorate General of GST, who is not the proper officer under section 74 in the instant case and has no jurisdiction to issue the show cause notice. It is submitted that the show cause notice issued by the additional director, the Directorate General of GST Intelligence, is without jurisdiction, and since the jurisdiction goes to the root of the list, the entire adjudication proceedings is illegal and void. Please take this as a part of a reply to the above show cause. My lord, they have not at all dealt with this aspect, with this, my lord, the dispute which I raised. Now, my lord, in this matter, so my lord, before your lordship is that they are assuming jurisdiction. The intelligence wing is assuming jurisdiction on the basis of a circular. But my lord, I'm relying upon a judgment of the Supreme Court, my lord, which my learned junior will submit to you, my lord. It is Bengal Iron Corporation and another versus Commercial Tax Officer and others. That is 1994 Supplementary 1 Supreme Court cases 310. My lord, let this, my juniors are there, let them, my lord, submit this judgment to your lordship. My lord has the judgment?
Yes, yes.
My lord, I'm drawing your lordship's kind attention to paragraph 18 of the judgment. So far as clarification / circulars issued by the central government and the state government are considered, they represent merely their understanding of the statutory provision. They are not binding upon the courts. It is true that those clarifications and circulars are communicated to the concerned dealers. My lord, it was in that particular case. But even so, nothing prevents the state from recovering the tax if in truth such tax was leviable according to law. There can be no estoppel against the statute. The understanding of the government, whether in favor or against the SSC, is nothing more than its understanding and opinion. It is doubtful whether such clarifications and circulars bind the quasi-judicial functioning of the authorities under the Act while acting in quasi-judicial capacity. They are bound by law and not by any administrative instructions, clarifications, or circulars. So law is what is declared by the court and the High Court. So my lord, I am relying that a circular is not binding upon the court. It is also not binding upon the SSC. And it is, according to this judgment, my lord, it is also not binding upon the quasi-judicial authority who is, my lord, adjudicating the matter. But my lord, they have not made a whisper about this, their lack of jurisdiction, not have dealt with the adjudication order. That is mine. And my lord, therefore, since I'm stating that they have derived the DGGI, that is the investigation wing, has derived its authority from this circular, my lord, I have also prayed that clause 6 of that said circular may be struck down and declared as illegal and invalid because it is in derogation of the statute. My lord, my second argument is that, my lord, I have specifically in my reply my lord, which starts from page, I think, 233. No, my lord, 333. I'm sorry, my lord, 333. I have stated, first of all, my lord, page 333.
Reply is 367.
Yes, it starts from 333. It starts. My lord, I have stated that you have relied upon certain statements made by certain officers, certain persons. Now, my lord, I have stated that I would like to cross-examine them. My lord, one of the persons who has said that he said that he was a broker, but he did not, the goods were not delivered to me, that is to the petitioner. My lord, kindly see, my lord, page 344. With reference to paragraph 5.3 of the SCN, my lord, paragraph 8, we deny the allegations made in the statement dated 14/9/2018 made by Surendra Patwari before the DGGI, which is annexed as RUD 15. We deny the allegations contained therein and request to be allowed to cross-examine Surendra Patwari. Moreover, Sri Shyam Sundar Agarwal of Shyam Steel Company, who sent the consignment to us, also disagreed with the statement of Sri Surendra Patwari recorded on 14/9/18, which will be evident from RUD 16. So, my lord, there were people, though the suppliers were supporting me and saying that, yes, we have transferred the goods to the petitioners and they have made payment to us, payment to the, my lord, suppliers. No, my lord. Again, my lord, paragraph 10, my lord, page 345. With reference to paragraph 5.6.1 of the SCN, we deny the allegations made by Naveen Sarogi, proprietor of C. Alloys Trade Company, in a statement dated such and such, that they have issued fake invoices to us and have passed irregular ITC to us annexed at RUD 19. If Sri Alloys Trading Company had not supplied the good to us, why should we make payment through bank to Sri Alloy Trading Company? We would like to cross-examine Sri Naveen Sarogi of Sri Alloys Trading Company. Similarly, my lord, there were others, the transporters. In all cases, my lord, we have said we would like to cross-examine them. My lord, there is no whisper in the adjudication order regarding, they have recorded my prayer, but they have not dealt with it. And they have also not said why it could not be dealt with it. Similarly, my lord, regarding the transporter who said that he had only issued consignment notes and bilties, but my lord, we also said that we would like to cross-examine him, but that was also not allowed. Payment. And my lord, also kindly see at paragraph 9, that is at page 344, we have written, my lord, 344, paragraph 9. With reference to paragraph 5.3.2 of SCN, we deny the allegations made by Bijoy Singh in a statement dated such and such being annexed as RUD 16. In reply to question number 5, he has stated the transport bilties were signed by his son Kunal Singh, and in reply to question number 6, he has replied that he has not authorized his son to sign the bilties, but he used to sign the bilties in good faith. The bilties therefore are not fake. We deny that Surendra Patwari had paid rupees 500 per bilty to his son. Singh Road Lights has received payment for transportation from us through bank, as evident from the ledger account of Singh Road Line, and the statement dated 20 such and such of Bijoy Singh cannot be relied upon. It is evident from the bilties that the rubber stamp put on the bilties was as proprietor. We request to allow us to cross-examine Bijoy Singh and Kunal Singh in this respect. We deny that Surendra Patwari had paid rupees 500 per bilty. My lord, similarly, we have prayed for all the others who have paid, who have made adverse comments on us. My lord, no cross-examination has been allowed. My lord, in this respect, my lord, I rely upon another judgment of the Supreme Court, my lord. My lord, this is a judgment of by the Supreme Court in Andaman Timber Industries versus Commissioner of Central Excise, Kolkata. My lord, reported in 2016, 15 Supreme Court cases, 785. My lord, my learned junior, my lord, will submit the case law to your lordship. My lord, has the case? My lord,
Yes.
Yes. Then my
Yes,
lord,
I've
may
got
I
it.
paragraph 6. My lord, in that case, in Andaman Timber, my lord, they refused. The tribunal said no purpose will be served by giving a cross-examination. And my lord, paragraph 6, Supreme Court has dealt with this. According to us, not allowing the SSC to cross-examine the witnesses by the adjudicating authority, though the statement of the witnesses were made, the basis of the impugned order is a serious flaw, which makes the order a nullity, inasmuch as it amounted to violation of principles of natural justice, because of which the SSC was adversely affected. It is to be borne in mind that the order of the commissioner was based upon the statements given by the aforesaid two witnesses. In my case also, my lord, the order has been based solely upon the statement given by certain suppliers and Surendra Patwari and Vijay Kumar Singh. My lord, the transporter, and Surendra Patwari is the broker. Even when the SSC disputed the correctness of the statements and wanted to cross-examine, the adjudicating authority did not grant this opportunity to the SSC. It would be pertinent to note that the impugned order passed by the adjudicating authority, he has specifically mentioned that such an opportunity was sought by the SSC. My lord, in my case also, in his adjudication order, the adjudicating authority has recorded by submission that I have prayed for a cross-examination, but not dealt with it. However, no such opportunity was granted, and the aforesaid plea is not even dealt with by the adjudication authority. Same here, my lord. As far as the tribunal is concerned, we find that rejection of this plea is totally untenable. The tribunal has simply stated that cross-examination of the said dealers could not have brought out any material which would not be in possession of the appellant themselves to explain as to why their factory prices remains static. Now, my lord, paragraph 7. As mentioned above, the appellant had contested the truthfulness of the statements of these two witnesses and wanted to discredit their testimony, for which purpose it wanted to avail the opportunity of cross-examination. That apart, my lord, this is in that particular case what the adjudicating authority had done. This is that fact. This is not the law. My lord, then in paragraph 8, in view of the above, we are of the opinion that if the testimony of these two witnesses is discredited, there was no material with the department on the basis of which it could justify its action, as the statement of the aforesaid two witnesses was the only basis of issuing the show cause notice. We thus set aside the impugned order as passed by the tribunal and allow this appeal. So, my lord, in similar matter, it has not been dealt with why they will not offer me an opportunity for cross-examination. No, my lord. My third challenge was, my lord, was that I stated, my lord, they have issued me a show cause notice for the period 17-18 clubbing 2 years and 18-19. Now, my lord, in 17-18, my lord, they said that ITC wrongly availed is 1,08,36,439, which is at, my lord, page 334 to 336. And for 18-19, they have stated that I am ineligible for 81,52,904. Now, my lord, our submission was that you cannot club multiple years in one show cause notice and in one adjudicating order. My lord, and this also we stated in our reply. They have recorded in a reply, and my lord, they have also justified why it can be done. My lord, I'm placing before your lordship their justification. My lord, kindly bear with me. My lord, I'm placing the particular relevant page. My lord, it is, my lord, page 419 is the reason for the order. Page 419. My lord, the reason for the order starts from page 491. My lord, it says now, if your lordship kindly sees paragraph 5.4, now I am going to discuss above mentioned allegations and defense submissions notice-wide based on extant provisions as well as available factual positions. My lord, there were several notices. They have dealt with all those notices. Now, my lord, regarding what they have stated about multiple years, my lord. It was, my lord.
Madam, sorry, but it would be page
My lord.
491, not 90.
500, my lord. My lord. He says, my lord, 500.
Discussion starts.
My lord, in the reply, my lord, kindly come to 1, 2, 3, 4, 5, fifth paragraph of 500. In the said reply dated 22/9/2025, the noticee has cited judgment of the Division Bench of the High Court at Kerala in Ernakulam in Joint Commissioner Intelligence and Enforcement's SGST Department, Thiruvananthapuram and others, and versus Lakshmi Mobile Accessories. For the discussion purpose, relevant provisions of Section 474 are considered here. Now, my lord, it says, Section 74(1), where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit. My brief has fallen down. My lord. The heavy brief, my lord. 40 minutes brief. My lord. My lord, I'm sorry, my lord. My petition fell down. My lord. Yes, my lord. My lord, page 5. My lord, where
We'll carry it after lunch.
the proper officer that
After lunch. Ms. Mukherjee, after lunch.
My lord.
We'll take it up after lunch.
Yes. I'm grateful, my lord. Yes.
Yes, sir.
My lord. My lord, may I start, my lord?
Yes, yes.
My lord, I was going through page 500 of the writ petition, my lord. My lord, kindly take that up. My lord, I had challenged the show cause notice for in, for multiple years. That is, they 2017-18 and 18-19. And now, my lord, kindly see how they have dealt with it. And I have also relied upon a judgment of the High Court of Kerala, Ernakulam bench. That is Joint Commissioner Intelligence versus Lakshmi Mobile. My lord, I'll come to the judgment later. My lord, let's see how she has dealt with it. In the context, section 74(1). My lord has it, my lord, page 500.
Yes.
My lord. In the context, section 74(1). For the discussion purpose, relevant provisions of section 74 are considered herein. Now, my lord, it says, in the context. My lord has it? My lord, it's
Yes,
1,
yes.
2, 3, 4, 5, 6 paragraph of that reply of the adjudication order. My lord has it, my lord?
Yes.
My
Yes,
lord.
I have it.
In the context, section 74(1), where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has been so short paid, or to whom the refund has erroneously been made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice, along with interest payable thereunder under section 50, and a penalty equivalent to the tax specified in the notice. Now, by careful, this is the observation of the adjudicating authority, next paragraph, my lord. By careful reading, it is observed that the section 74(1) is not asking for issuing the notice year-wise. The provisions are highlighting the circumstances when a notice should be issued, and the notice shall require from the person to show cause as to why he should not pay the amount specified in the notice. Therefore, according to the section 74(1), a notice may be issued for multiple years. Now, section 74(9), the proper officer shall after
All right, madam,
consider-
I'll issue notice. Madam,
Yes,
I'll issue
madam.
notice. Let them
Yes,
file.
madam.
Let them file the reply.
Yes, my lord. My lord, I'm grateful. My lord, only thing I would like to make my submission before your lordship. My lord, they have already recovered 1 crore of my demand at the time, 70 lakhs at the time of search and seizure, and 20 and another 25 lakhs, my lord, forcefully they coerced me to pay. So I am praying, my lord, my demand for 2 financial years are 1 crore 90 lakhs. Now, my lord, if I had to go in appeal, I would only have to pay 10% of the disputed tax. My lord, since they have already taken away 1 crore of the disputed amount, my lord, I am praying that no coercive action should be taken against me till the matter is decided.
My lord, in this case, the petitioner is harping on issue that the DGGI has no authority to issue show cause notice. First point is that DGGI has no authority to issue show cause notice. On the in support of her contention, she gone through the notification circular, which was issued circular number 31/18. My humble submission is that circular number 31/18 was issued on 9 February 2018. Before that, There is a gazette notification, not the circular.
File your reply, Mr.
Yes, I can file the reply by way of affidavit. Kindly allow me to submit affidavit because notification number 1417 is clear, wherein the DCGI authority has the power to issue adjudication, to issue the show cause notice, and in view of another circular, they can forward the show cause notice to the appellate authority, for passing necessary order. So I am willing to submit this circular by way of affidavit.
On the petition.
And also other documents.
Petitioner. Only one petitioner, right? The company. Savaria.
Yes, my lord.
Only one petition.
Right now, there is only one
petition. The petitioner, by way of the present petition, has challenged the show cause notice dated 9/6/2022, issued by the Additional Director, Director General of Goods and Service Tax Intelligence, DDGI bracket medal. Siliguri unit, Siliguri zonal unit, comma. The order in original dated 17/11/2025, passed by the respondent number 5, as well as the consequential demand notice issued in the informed GST DRC 07 dated 25/11/2025 for the tax period 2017.
17, 18 and
17
18.
to March 2017, July 2017 to March 2018, and April 2018 to March 2019. Full stop. The petition has also assailed the validity of paragraph 6 of the circular number 31/05/2018, insofar as it authorizes officers of the DDGI to issue show cause notice under section 74 of the relevant act. Learned counsel for the petition states that there is a second round of litigation between the parties. Full stop. Earlier, an order in original dated 24/12/2024 had been passed, followed by a demand notice dated 22/11/2025. Full stop. The petitioner had challenged the same before this court in WPA number 599 of 2025. Full stop. By order dated 37/2025, the learned single judge disposed of the said writ petition, granting liberty to the petitioner to avail the statutory remedy available under section 107 of the Act. Full stop. Being aggrieved thereby, the petitioner preferred an appeal before the Honorable Division Bench in MET 68 of 2025. Full stop. The Honorable Division Bench, by order dated, what is the date of the order? Same.
8/9/2025.
8/9/2025. 8/9/2025, set aside the order of the learned single judge and remanded the matter back to the adjudicating authority for fresh consideration, with a specific direction to supply all relevant relied on documents to the petitioner. Pursuant thereto, the respondent authority supplied all the relevant documents. Full stop. The petitioner submitted its reply, and upon affording an opportunity of hearing, the respondent number 5 passed the impugned order in original dated 17/11/2025. Full stop. Consequential demand notices were thereafter issued, which are under challenge in the present writ petition. Full stop. Learned counsel for the petitioner submits that the show cause notice dated 9/6/2022 was issued by respondent number 3, whereas the adjudication has been carried out by respondent number 5. Full stop. It is contended that under section 74 of the Act, only the inverted comma mein kar dena, proper officer, inverted comma close, is competent to issue such notice, and therefore the initiation of proceedings by an authority other than the proper officer vitiates the entire proceedings. Full stop. It is further stated that that paragraph 6 of the circular dated 31/5/2018, which purports to authorize the DDGI to issue show cause under 74 is ultra vires the present statute in as much as it confers power not contemplated under the act. Full stop. Learned counsel for the respondent prays for and is granted. How much?
The notification. Is it notification?
How much time to file affidavit in opposition? 4 weeks to file affidavit in opposition. 4 weeks. 4 weeks. Who gives 4 weeks? 4 weeks. Reply 2 weeks. In the meantime, considering the nature of the challenge raised, particularly with regard to the jurisdiction and validity of the initiating notice, this court deems it appropriate to grant interim order, full stop. Accordingly, subject to the petitioner depositing 10% of the disputed amount within a period of 2 weeks. Additional 10%.
My lord, may I make one humble submission, my lord? My lord, I have already disputed more than 10. My lord, one submission, my lord, before your lordship. My lord, all I'm trying to say, more than 10% has been taken away from me by them. So I need not dispute any, I need not pay anything, my lord. More than 10% they have realized from me.
1 crore 97 was the demand. In total, my lord, they have taken in excess of 75 lakh from me.
No, 1 crore. They have taken 1 crore.
How much have you?
1 crore in excess of 70.
How much you have deposited? Is it more than 10% or not?
Yes, absolutely.
More than 10%.
Right.
My lord, my 10% would be 19 lakhs.
Much more than 10%.
My 10% would be 19 lakhs.
Appropriate to stay the operation of the impugned order in original dated 17/11/2025 and consequential demand notices issued pursuant thereto for a period of 8 weeks or until further order, whichever is earlier.
Interest and penalty is also there.
So 10% they have already, it's more than 10%. they
More
have
than
deposited.
10%. My lord.
Yes, but the amount is more than 19 lakh, 19.
My lord, the amount is 1. My lord, may I
No,
submit?
1 crore 19.
1 crore 90
90
lakhs. is what
And
they
they
say.
have taken 1 crore.
1 crore 90.
And they have paid 1 crore.
1
what
crore,
they're
my
saying. So
lord.
it's more than 10%.
Taken away from me, which is more than 10%.
1 crore 90.
Whichever is earlier, list.
My lord, I have
After.
filed the circular. Kindly mention this in there.
What will the circular do, sir? Yeah, I'm letting you file the affidavit.
Yes. Okay. All right.
List after 8 weeks before the available circuit.
But if you
6 weeks. List after 6 weeks before the.
My lord, I am grateful, my lord, for giving me a patient hearing, my lord.
Demand notices. Whichever is earlier. 13/5. 18. 74 under section 74. Not contemplated under that. Under the act.
But I have submitted the affidavit of service.
Affidavit service taken.
No further deposit.
এটা নিন
देखना तो जाके
If it is a search, the statutory prerequisite is there should be a pre-search report. GST INS 01, inform GST INS 01. We wanted a copy of that pre-search report. Even that was never granted. Nobody talked about this. They have recorded my statement. Lord, I have a right to get a copy of my statement. Neither those copies, and thereafter, my lord, again at page 57, if lordship sees, right from page 56. I have time and again written them, 56, 57. I have time and again written them. Kindly give me a chance to appear online. But that they are not relenting to, very well. Even if that is not being relented to. Now lordship kindly comes to page number 76. This is provisional attachment. This was the last straw. I'm placing the small 3 paragraphs. It is to inform that measures EPC International, that's my lord, the petitioner herein, having PPOB at Raninagar Industrial Growth so and so, bearing GST registration number so and so, is a registered taxable person under the CGST SGST Act. Proceeding have been launched against the aforesaid taxable person under section 67(1). My lord, 67(1) is the search proceeding of the said act to determine the tax or any other amount due from the said person. As per information available with the department, it has come to my notice that the said company has a bank account in your bank having account number so and so. In order to protect the interests of revenue and in exercise of the powers conferred under section 83 of the Act, I so and so hereby provisionally attach the aforesaid account. No debit shall be allowed to be made from the said account or any other account operated by the aforesaid company with the same PAN number without prior permission of this department. There are 2 things that I would like to highlight. Number 1, nowhere in this order have they reflected that I have a reasonable suspicion they are trying to dispose of their assets, which is a sine qua non of applicability of section 83. Section 67, that is search, they can act on a tip of information, but this they cannot. Secondly, last paragraph, no debit shall be allowed to be made from the said account or any other account operated by the aforesaid company. They are seizing one and passing a blanket thing. Now, lordship, kindly take section 83 once. What does section 83 say? Lordship has the book, or should I?
Give me the, this is.
May I?
GST Act.
Onto section 83 though. My lord will forgive me for marking in my book. Give me the text. Anybody? Thank you. Section 83 I'm reading. Where after the initiation of any proceeding under chapter 12, chapter 14 or chapter 15, the commissioner is of the opinion that for the purpose of protecting the interest of government revenue, it is necessary so to do. He may by order in writing attach provisionally any property including bank account belonging to the taxable person or any person specified under so and so in such manner as may be prescribed. Very open-ended provision, my lord. Now, this was read down by Honorable Gujarat High Court, by Honorable Justice Parthival as he then was, my lord. And upon that reading, the CBIC themselves passed a notification implementing that reading. That notification I have annexed. And I'll show your lordship what CBIC has actually meant by that. Lordship kindly takes page number 82. That is the notification. It starts from 82. Lordship will kindly come to straight away page number 86. 3.4.4, page number 86. This is their notification. Movable property should normally be attached only if the immovable property available for the attachment is not sufficient to protect the interests of the revenue. Number one. Next, as far as possible, it should be ensured that such attachment does not hamper normal business activities of the taxable person. This would mean that raw materials and inputs required for production or finished goods should not normally be attached by the department. Next, in cases where the movable property, including bank account belonging to the taxable person, has been attached, such movable property may be released if the taxable person offers, in lieu of that movable property, any other removable property which is sufficient to protect the interest of revenue. Then the last line, my lord, sees the heading investigation and adjudication. Lordship kindly turns the page. As the provisional attachment of property is resorted to protect the interests of the revenue and may also affect the working capital of the taxable person, it may be endeavored that in all such cases, the investigation and adjudication are completed at the earliest, well within the period of attachment, so that the due liability of tax as well as interest, penalty, etc. arising up.
How much is the penalty which they are alleging?
I have no clue. Not a single line has been communicated to me.
Nothing, no.
Nothing. Excepting these summons, I have received not a scrap of document from them. I do not know what is standing against me, how they are alleging, how they are calculating, and what they are calculating. I'm at complete darkness. And my lord, finally, the Gujarat High Court order, which have fine. But we will kindly take paragraph 44 and 54. Paragraph 44, perhaps.
Paragraph?
44. Paragraph 44 perhaps brings out the very jurisprudence, the very fundamental pivot behind this provision. We would like to add something more to what we have stated above. It would be a big mistake on the part of the respondents to understand that the reasons to believe necessary for the purpose of carrying out inspection, search and seizure under section 67 of the Act 2017 would be sufficient enough for the purpose of formation of the opinion that is necessary to provisionally attach the goods or other articles for the purpose of protecting interest of the revenue. In our opinion, section 83 of the Act stands altogether on a different footing. The considerations also are quite different for the purpose of exercising the power of provisional attachment under section 83 of the Act. Just because some proceedings are initiated under section 67 by itself would not be sufficient to arrive at the satisfaction that it is necessary to provisionally attach the property for the purpose of protecting the interests of the government revenue. The power has been specifically conferred upon the commissioner to form such an opinion. The legislature was quite alive to the fact that an order of provisional attachment cannot be as a matter of course. It is one of the drastic measures which the authority may be compelled to take if the situation demands for the purpose of protecting the interest of the government revenue. Pausing here for a moment, my lord. So, section 67 proceeding will not ipso facto qualify section 83 proceeding. Now 54. Not 54, my lord, 52. I stand corrected. 52. Our final conclusions may be summarized as under. 1 is not relevant, so I'm not placing. From 2, the power conferred upon the authority under section 83 of the Act for Provisional Attachment would be termed as a very drastic and far-reaching power. Such power should be used sparingly and only on substantive, weighty grounds and reasons. The power of provisional attachment under section 83 of the Act should be exercised by the authority only if there is a reasonable apprehension that the assessee may default the ultimate collection of the demand that is likely to be raised on completion of the assessment. It should therefore be exercised with extreme care and caution. Number 4, the power under section 83 of the Act for provisional attachment should be exercised only if there is sufficient material on record to justify the satisfaction that the assessee is about to dispose of wholly or any part of his or her property with a view to thwarting the ultimate collection of demand. And in order to achieve the said objective, the attachment should be of the properties, and to that extent, it is required to achieve this objective. There are 5.
Six.
My lord? Six. Yes. Attachment of bank account and trading assets. So, my lord, the fundamental principle has been completely narrowed down. There is no such findings whatsoever. That will be the class of my submission.
Mr. Manik,
My lord, in this case,
if you don't have a quantified amount, why have you attached his bank account?
They are not cooperating. They have never appeared.
They'll appear, they're saying, I'll record the statement.
Moreover, I have a document.
They'll make a statement, they'll appear.
No, they have not provided any documents.
What kind of documents? They will go and provide the document, look at the kind of your summons are there.
Which are mentioned in the summons, my lord.
Look at the summon itself is faulty.
Moreover, after attachment, they have filed an objection, and on the basis of that, personal hearing notice was issued.
Very good.
And on the same day, he did not appear. Tomorrow is the date.
All after filing the writ. All after filing the writ.
Before filing. Tomorrow is the date for his appearance. I am holding the notice for his personal appearance.
Personal appearance.
Here is the document, my lord.
Personal appearance is not needed. What will the director do? The accountant will suffice.
By person hearing,
I would like to bring this.
anybody will go.
Exactly.
Anybody will go. Any authorized person can go.
Yes, but they are not.
They will go. I will record
I
that.
will go personally tomorrow.
I'll record it.
They are not.
Hey, Mr. Manik, he is
either-
making a statement.
Either personally or through authorized representative.
That's what I'm saying. They will go.
Yes.
But
You decided
personal-
tomorrow.
But personal hearing is fixed on tomorrow. It is the personal hearing as per request of the taxpayer. It is the personal hearing
No.
of that particular person.
Why particular person, Mr. Manik?
My lord,
Where is the act?
he prayed for. He prayed for.
No particular person.
But he prayed for.
Is that the act? Where is it in the legislature?
But according to his prayer, it was allowed that yes, he may appear before the authority.
We can smell what is happening here. We know exactly what is happening here.
My lord, he never cooperated. He
Who
never
cooperated.
properly
Look at the kind of summons which are being issued.
Tomorrow is the date fixed. Tomorrow he can appear or his representative can
We
appear.
know what is happening here.
His representative can appear tomorrow. It is the date, already date is fixed tomorrow.
You appear tomorrow.
Yes, my lord, I will.
This is absurd. Look at the kind of summons which are being issued. Pressurizing him to come. Settlement.
No.
Exactly, my lord. 35 lakhs have been quoted.
35 lakhs for depositing as government revenue.
Of
Initial
course.
deposit. For initial deposit.
Initially.
Yes.
And I do not know what I'm staring at.
Prima facie, it was found that you have evaded tax of 35 lakhs.
How did you find that? Where did you come? Where is the finding? You come with the file.
In that case, I will submit those findings.
Come.
Why
You
were
come
they-
with the file. Tomorrow you come with the file.
Yes. Yes.
But tomorrow is the.
He will appear day after tomorrow. Day after tomorrow.
Yes.
Let him appear. You come with the file.
Yes.
We will see how the officers are dealing with this.
Grateful, my lord.
Day after tomorrow. You go and appear tomorrow.
Yes.
We'll see that.
So, my lord, tomorrow your lordship is fixing it here.
No, you appear before.
Yes.
Day after tomorrow we'll have it here.
Day after tomorrow. Chuti nahi to.
No.
Very good. Very good. Very good. My lord, till then, no course of action may be taken.
Do you think they will take?
I don't. Grateful, my lord.
And convey Mr. Manik, the officers, no coercive action.
Matter is pending before my.
Otherwise, we'll take coercive action.
I'll send one of my own juniors. Great.
Item number 30.
Please appear together the document.
Akshay. This matter, my lord, is a very straight case. No opportunity of being heard was given.
Item 32.
Yes. 30.
Item number 30.
Lordship will kindly see the. I won't trouble you, Lordship, with much, but Lordship will kindly see the show cause notice at page 38. 37, Lordship kindly takes. That's the show cause notice. There was a pre-show cause as well, but I will come to that later. But Lordship will kindly appreciate the show cause notice first, page 37. It's a horizontal paper. And the next page. The next page, page 38. 37 it starts, and at page 38. Date by which reply has to be submitted, 26/10/2023. Date of personal hearing not applicable. Time of personal hearing not applicable. Venue where personal hearing not applicable. I went there on 26/10/2023 with my documents. And now Lordship kindly takes page 39 and thereafter 40. Page 39 is the government calendar of the state government of West Bengal. Page 40 shows 26/10/2023 was a holiday. So of course, I went there, came back, and thereafter the order was passed. 26th of October. Lordship at page 38, 26/10/2023, reply date given in the box. And thereafter, my lord will see page 39 is the notification of Calcutta state government list of holidays, West Bengal government's list of holidays. Page 40, 1, 2, 3, 4, 5, 6, 7th entry from the bottom in the first table.
Yes.
Additional day for Durga Puja, 26th October, Thursday.
Yes.
And thereafter the final order was passed. 75(4) below is preview of, it says that no order can be passed without giving me an opportunity of being heard. There was a show cause notice, pre-show cause notice as well. In pre-show cause notice also they said you come and give your reply, but no personal. What happens here, the difficulty is the books of accounts have to be produced and have to be explained. Otherwise, one would not be able to tally it. Only a letter will never do. So that is why personal hearing is very necessary. And that has not been given. In identical situation, coordinate bench's judgment is there. It must be here, na? May I place?
Yes.
This is reported in 142 GSTR 199. May I place? Learned counsel for the petitioner submits as follows. A pre-show cause notice issued was not uploaded in time in the official portal, so the petitioner did not know it. So far as the show cause notice dated so and so is concerned, only a date was fixed for submission of reply, but no date was mentioned for personal hearing, which was essentially required by the petitioner to explain the show cause. The appellate order also does not properly appreciate the question. Here there was no appeal. Learned counsel for the state denies the allegation. Thereafter, skipping last paragraph, whether a pre-show cause notice was issued and uploaded in the portal or not, the show cause notice dated so and so does not provide a proper opportunity of personal hearing to the petitioner. It appears that the case is about non-payment of tax due or short payment of it, or refund erroneously made or input tax erroneously availed for. Therefore, it was necessary for the authorities to grant an opportunity to the petitioner to have a personal hearing where books of accounts could be produced and the issues explained. No such opportunity was provided by the tax authorities. Here there was no appeal. In fact, accordingly, the show cause notice was quashed. This is the proposition. Yes. This is the citation.
And it's covered by section 75.
Four.
Where it clearly says that an opportunity of hearing shall be granted where any adverse decision is contemplated against such person.
Where's the final order which is under challenge?
My lord, the order is at page number 35.
সাইটেশনটা না ওখানে জাজমেন্টটা দিয়েছি সাইটেশনটা লেখা
Yes.
Page
65.
35, my lord.
Page
65 is the adjudication order.
65.
65, I stand corrected. এত কথা বলো না মাঝখানে মুশকিল হয়ে যায়।
Take down. The petitioner has preferred the present writ petition being agreed by the, this is an ex parte order, right?
My lord,
Ex parte adjudication order dated
order is dated 17/8/2023.
So this is a reference
No,
date.
order is dated, my
What is
lord.
the date of the order?
No. I stand corrected once again. 15/1/2023. 15/12/2023. 15/12/2023. Yes.
15/12/2023 passed by the Assistant Commissioner of Revenue, Kuch Bihar charge. Kuch Bihar, whereby the, see the Kuch Bihar, whereby the said authority confirmed the demand of tax, interest and penalty as proposed by the show cause notice. Show cause notice dated
Show cause notice dated
26/9/2023. Full stop. The case of the respondent authority is that the petitioner had filed nil returns in form GSTR 3B for the period 1/7/2017 to 31/3/2018, where the petitioner's form 26AS for the same period reflected turnover, outward supply amounting to rupees 161.91 lakh. Full stop. On the basis of this, on the basis of such discrepancy, it was alleged that the petitioner had suppressed turnover and failed to discharge the corresponding tax liability. Based on the aforesaid allegation, a show cause notice dated 26/10/2023 in form DRC 01 under section
26/9.
73(5) of the
26/9/2023.
26/9 or 26/10?
26/9/2023. 2023.
Section 73(5) of the WBGST Act, read with GST Act 2017, was issued. Admittedly, the petitioner did not file any reply to the said show cause notice, nor were supporting documents furnished before the adjudicating authority. Consequently, the respondent proceeded to pass the impugned ex parte adjudication order dated 15/12/2023. Learned counsel for the petitioner submits that the show cause notice itself is faulty since the petitioner was not granted the opportunity of personal hearing as contemplated under section 73(5) of
75/4.
74(5)
75/4.
75(4) of the said act. Full stop. Of the act, of the act. Full stop. Learned counsel for the petitioner has handed over a copy of this, copy of a judgment passed by the coordinate bench of this court in WPA number 410 of 2025, wherein this court by order
Reported
dated
in 142 GSTR 199.
wherein the court, this court, wherein this court by order dated 3/3/2025 had held that show cause notice, which does not provide a proper opportunity of hearing to the petitioner, is faulty, and that it is necessary for the authorities concerned to grant an opportunity to the petitioner to have a personal hearing where book of accounts could be produced and the issue could be explained. No such opportunity was provided by the tax authorities. He has further relied on the judgment of this court in 2026-182 Taxman 778, title so and so, wherein Where's the, what are you relying on in this?
My lord, this is 142 GST or 199. I've relied only on one judgment.
Only one judgment you have relying
Only
on,
one
not on this one.
No, that is the judgment, my lord. I just said the reporting number, the citation I said.
No, which one you are relying?
142 GST or 199. This one, Anup Jindal.
Anup Jindal. Right?
Anup Jindal. That is reported in 142 GST.
Not on Rajkumar, no?
No.
Anup Jindal, all right. क्या लिखा है? हाँ वो छोड़.
A bit different. No, different issue. No, different issue. Yes.
Keeping the dicta of the above relied on judgment, applying the dicta of the above relied judgment, this court holds that the show cause notice issued to the petitioner on 26/9/2023 nowhere had provided the opportunity of hearing to the petitioner. Full stop. This is itself contrary to section 75(4) and is supported by the judgment of the coordinate bench. Full stop. Having regard to the same, this court, the show cause notice dated the order dated 15/12/2023 is set aside. Order dated so and so and the show cause notice dated so and so is set aside. The petitioner is relegated back to the adjudicating authority for the adjudicating authority is directed to issue a fresh show cause notice and thereafter pass an order in accordance with law. Full stop. With the aforesaid observation, the present petition stands disposed.
Grateful. Look, affidavit of service.
Affidavit of service taken. Next.
Item number 31.
Additional notice, my lord.
This is also yours.
Yes. Yes, my lord, it's also.
What is that?
My lord, additional notice. All the notices and pre-show cause and show causes were uploaded in the additional notice side of the portal.
Okay.
I've given the screenshot.
That's
Page 60.
There was that judgment. Where is that?
My lord, this one was the first of this. I do not know whether the lordship is.
That in that file there's a judgment.
This is the one that was first time given in the citation is given.
Which was the other matter? Do you recall? Which was that?
Yeah.
Where is that? You have the judgment.
I don't have right now. I have the soft copy.
You have? Just give it.
Other judgment additional notice.
I'm seeing that.
Just give it. Take down. The petitioner has preferred the present petition, challenging the ex parte adjudication order and the notice of demand ex parte adjudication order dated 8th of
August
August
2022.
2022 and notice of demand dated 8th of August 2022.
Same even.
Huh?
Even date.
Same. These are the two things which you have
And
challenged.
show cause notice.
And the show cause notice
Dated
issued on
8th of July
8th of
2023.
July 2023.
And also the
As well
pre-show
as,
cause
as
notice.
well as the pre-show cause notice dated 3rd of June 2020. Learned counsel appearing for the petitioner submits that the adjudicating authority passed the impugned order in violation of principles of natural justice, in as much as the notices were not effectively brought to the knowledge of the petitioner. It is contended that the notices were uploaded under a separate tab, namely inverted comma mein additional notices and orders, inverted comma close. And the petitioner remained unaware of the same, resulting in the ex parte adjudication. It is further submitted that the petitioner came to know about the impugned order only in
December 2025.
December
upon a call from the
2025
department.
upon receiving a communication from the GST department regarding outstanding very difficult to read. Others.
You actually very good. It's a yellow. আমাকে পাঠাও না আমার মোবাইলে পাঠাও
Did you file an appeal here?
No, because the time was already over when I got to know. Yes, sir. তাহলে সুবিধা পাঠাও 9-4.
The petitioner states that due to improper tabulation of notices, he could not participate in the adjudication proceedings.
Voluntary.
The petitioner has relied upon an order passed by this court in WPA number 1517 of 2024, wherein this court on 22/8/2024 has held that the petitioner that the petitioner cannot be held liable for the ex parte assessment order since it was under a bona fide impression that no notice or assessment was issued to him, and that the publication of the and that the was issued to him. The court had further held that the GST website manual and FAQs specify that notices should be available under the Notices and Orders tab. Full stop. Accordingly, the court had set aside the order of the appellate authority. Full stop. Keeping the dicta of the directions of the order, following the law precedent and the observations of the coordinate bench of this court in WPA number 1517 of 2024. This court cautions the impugned order and cautions the ex parte adjudication order dated. What is the date? 8/8. What is the date?
The
15. Order dated so and so, so and so.
8th
so and
August
so,
2022.
as well as the show cause notices, show cause
8th
notice
July
and the pre-show
2022.
cause notice dated so and so. The revenue will be at liberty to issue a fresh notice for adjudication against the petition.
And pre-show cause notice is 3rd June 2022.
All open लिखा हुआ है. Ex parte order, all right. Show cause, pre-show cause. ठीक है? The revenue will be at liberty to issue a fresh notice for adjudication against the petitioner for the relevant assessment within a period of 1 month from date. Full stop. The period of limitation shall start from the date of fresh notice. Full stop.
There is a 2-year time. Shall be
I'm not
provided by
pressing. I'm not pressing that.
the-
I'm not
by the
pressing that.
time period,
Since the honorable court has intervened, I will not press on that.
time do not give any time.
No time frame.
Static says 2 years from the date of the order.
All right. The revenue will liberty to issue fresh notice for adjudication
Yes, yes.
against the petitioner for the
Fresh
relevant assessment
pre-show cause
period.
notice.
Full stop. All right. The period of limitation, should I put that or not?
No, Lordship.
All right. The Special Commissioner, State Revenue, North Bengal shall bring this order to the notice of the GSTN for necessary correction on the web portal.
That has already been done now.
Leave that accordingly, the petition is disposed of.
Great. Lord affidavit of service.
With the aforesaid direction, the present petition stands disposed of.
Affidavit of service.
Affidavit of service taken on.
Item number 32.
Spy application.
This is also yours. No more, not for today.
This will be only 1 minute. In fact, my learned friend is also with me here. 10% deposit needed to be given before preferring of appeal.
Yes.
The gentleman couldn't give it at that point of time. Now he is desirous of giving. My lord will give you an opportunity. It's as easy as that. I won't.
Petitioner. Take down. The petitioner preferred the present petition being aggrieved by the order dated
The order is
30/11.
communication dated
30
2011-2025.
2011-2025 passed by the appellate authority, whereby the statutory appeal preferred by the petitioner under section 107 was summarily rejected on the ground of non-compliance of the statutory required pre-deposit of 10%. 10% of the disputed tax. Full stop. The facts in brief are that on the basis of a mismatch in taxable turnover for the period, this is December.
Period is 17-18. No. 17-18. 17-18 F5.
For the period 2017-18, as reflected in the return filed by the petitioner in form GSTR 1 and GSTR 3B, vis-a-vis the turnover appearing in form 26 AS, as notice dated 5/10/2023, was issued to the petitioner. Full stop. Due to discrepancy in the said 26 AS, the notice was issued to the petitioner. Show cause notice was issued to the petitioner on 5/10/2023. Full stop. A further notice dated 6/10/2023 was also issued. Full stop. None appeared on behalf of the petitioner and no reply was filed. Comma. The matter was referred to adjudication under section 74 of the Act and a notice under 74(5) was issued. Full stop. Although the petitioner did not file a reply within the stipulated time, subsequently he appeared in person and produced relevant records. Upon consideration of the materials placed on record, the authority passed an order dated 11/12/2024
11-1.
11-1-2024, determining his tax liability. Being
No, no,
agreed-
no, Lordship was right. It was 11-12, the sign
11
says so, yes.
11, that's what it
Yes,
says,
yes,
11-12.
yes, yes.
11,
That was the date of the case creation.
Page 4. Roman
Yes, yes,
4.
page 24, yes.
11-12-2024, and produce, determining his tax liability, full stop. Being aggrieved thereby, the petitioner preferred a statutory appeal under section 107 of the said act. The petitioner failed to deposit the mandatory pre-deposit as required under section 107, subclause 6 of the act. Consequently, the appellate authority rejected the appeal summarily on 30th-1-2025.
Yes. 2011-2025.
20th November 2025, full stop. Learned counsel appearing for the petitioners submits that the petition is ready and willing to deposit a sum of rupees
10%.
10% of the statutory pre-deposit and place for an
Deposit.
praise for an opportunity to prosecute his appeal on merits, full stop. Learned counsel for the respondent states that he has no objection to the said offer of the petitioner, full stop.
Right.
Having heard the counsel for the parties and upon consideration of the materials placed on record, this court finds that the requirement of pre-deposit under section 107(6) of the act is mandatory in nature and the condition precedent for maintaining an appeal, full stop. In the absence of such compliance, the appellate authority cannot be faulted for rejecting the appeal of the petitioner, full stop. However, considering that the petitioner has now expressed his readiness to comply with the statutory requirement, the petitioner has expressed his readiness to comply with the statutory requirement, and in order to afford an opportunity to have his matter adjudicated, this court is of the view that a limited indulgence can be granted, full stop. Accordingly, the impugned order dated 29/11/2025, 29/11, right? 2011/2025, passed by the appellate authority is set aside, full stop. The petitioner is directed to deposit 10% towards the statutory pre-deposit within a period of
2 weeks, Lord.
within a period of 2 weeks from date upon such deposit being made, comma, the appeal shall stand restored to its original file and number before the appellate authority, who shall proceed to decide the same on merits
Without going into the question of limitation.
in accordance with law after affording an opportunity of hearing to the petitioner,
Not without going into the question of limitation.
without getting into the question of limitation.
Yes.
Without entering into the issue of limitation. Full stop.
Great.
It is made clear that in the event the petitioner fails to deposit the aforesaid amount within the stipulated time period, this order shall automatically be vacated without furtherance to this court. With the above objection, the presented petition stands dismissed.
Grateful to you. Affidavit.
Affidavit of service taken on record.
Item number 33.
Will not take much time, Lord. I'm trying to rush it and I'm trying to not make your lordship suffer this.
He has got too many orders. Everybody should be treated here. You take everybody
Lord,
out.
I had also been waiting for the full week, my lord.
You didn't come. It's your fault.
Lord, I did. Once I appeared and then I said, since the medical emergency is at my home.
At least all the tax lawyer, you should
Yes.
take them out.
Take them out.
They all waited for you till almost 4 o'clock. How many more?
Lord, I'll be very candid. 3 matters more. Out of that, 2 matters can be wished away like anything right now. Because one, your lordship has already passed an order. It's covering that. In fact, 16.4. One is of 16.4. The other one is this. Time is
What is here in this?
My lord, this is GSTR 2B. There is a glitch in the portal. my GST 2B cannot be fully seen from the portal, and this was accepted by the appellate authority in the previous year. And in this year, the appellate authority did not accept that. That is the only thing.
Yes, Ms. Das. No,
I have attached the.
not today.
Acha, wait.
She's shaking her head.
Grateful. But 16/4, there is a matter on 16/4, the same order. Here I have only.
Wait.
Oh, wait, for it, no?
34.
I'm sorry. I'll wait.
Item number 34.
My lord, I'm paying for 1 day accommodation then service is not affected.
Learned counsel for petitioner states that the service has not been completed. He seeks an adjournment. Let the service be completed. List on.
It's the daily.
List before the next available circuit bench.
Should make it
I'm sharing this matter.
All right, day after tomorrow.
yeah,
Day after tomorrow.
I'm grateful.
This is the birthday gift that you are giving me.
Item number 35.
This is that matter where 16/4, that 16/4, 16/5 has been enacted, and there are four, as I was telling you, there are four notifications which give different dates. Here, the only
In
difference.
that one, it was 30/11/2021.
Yes, 2011, 8/11, 8/10,
30/11/2021. In
Yes.
that 8th of.
Yes, 8th of October.
October notice.
Yes.
30/11/2021.
Yes, there are two things. One is CGST, the other is WBGST. CGST gives 8/10/2024. WBGST also gives 8/10/2024, although the notification came in February 2025. In this matter, I have challenged all the four notifications on the ground that it cannot go beyond the statutory provision. And same matter, my lord, there was a coordinate benches order, your lordship's order is also there.
That is item number 36.
36.
This is 35.
This 35.
Oh, acha. Very well.
You have too many matters. You're getting confused. You have
This
taken
is
the entire board.
423. WPA 423.
Yes.
No, 423 is, তাহলে আমাদের এখানে ভুল লেখা হয়েছে, কি বলবে বলো, দাও অন্যটা দাও।
Too many matters here.
No. তোমার কাছে 423 তো?
হ্যাঁ।
তোমরা ভুল লিখেছো ওখানে, written it wrongly. 423, it's not 16/4. But here, adjudication order is at page 46. Page 46, my lord, kindly comes. This adjudication order, the last
Page.
46. The last four lines will speak for themselves. Taxpayer filed his reply in form so and so, where he prayed adjournment for 15 days. None appeared for hearing, nor any submissions made till date. Undersigned has reasons to believe that enough time and opportunities were given. Now, the difficulty is, my lord, this all goes in portal. When we are given a notice to appear, there is one tab to reply. In that tab, when I upload my adjournment request, they have to dispose it of, either say yes or say no. Otherwise, I will be in no position to upload a secondary document or a second document. Only when they give a reply, then only another reply button comes. And then only I can upload my replies. They did never give me any reply. So the only one reply tab was there. And in that, utilizing that reply tab, I've already uploaded my adjournment letter.
Yes, Vitas.
My lord, if your lordship comes to page 43, my lord.
43?
43.
Yes.
At the show cause notice.
Yes.
My lord, page 44 shows date of personal hearing was given to him along with date of reply.
Yes.
He appeared, he took 15 days time, my lord, and thereafter he did not appear, my lord. And thereafter on 27/12/2023,
Lord, that is the difficulty. If I have prayed for 15 days adjournment, that does not mean they have given me. And after 15 days, that date of 30.
No, look at your page 45, option for personal hearing, you say no.
No, that is a default, my lord. That is what happens. I'm not on a personal hearing here. I just wanted to file my reply. Had there been a reply, I could have very well visited. But I did not get a chance to file a reply as well. This GST DRC 06 Lordship is saying, this I uploaded in the reply button. There is only one reply.
It's an appealable order.
Yes, but the time is already exhausted, my lord. I should be very candid, my lord. The
He
time
did not
is
file
already
any appeal
exhausted.
against this adjudication order.
I could not.
Why?
Because I was waiting for their reply.
Please.
My lord,
You're
I
not
cannot.
you're not so innocent.
My lord, I was not there to guide the person concerned.
You can be innocent, but your client is not.
Lord,
Old bar sale, they were.
I have many good, jolly good friends in the bar.
I can see that.
I have very good friends in the bar. So, my lord, I would simply say, my lord, I will be very candid before your lordship. My lord, I cannot improve the case whatever I have in my hands. My lord, it is true that the time for appeal, preferring appeal, is gone. I have no other remedy in front of me.
He can file an appeal, my lord, with the condemnation of delay application.
And that will be.
You come after that.
My lord, what will happen? I'll tell your lordship. There is a divergence of opinion in 107.
You come after that, we'll see that.
Lordship kindly gives me.
Let the client
Gives me
suffer.
liberty. I will file that. I will file
Why
that.
should I? If I give you liberty, then I'm condoning your delay.
My lord, that is exactly what I wanted. That is my only prayer, because unless the delay is
you file your appeal with the condemnation of delay application, we'll see that.
my lord, unless the delay is condoned, my lord, the appellate authority will say we have no power.
You come after that.
My lord, after that there is a steep divergence of opinion, and after I'll be very candid again. After Justice Pardiwala's judgment, 7th January 2026, we do not stand a chance.
So good, then your rights are crossed.
My lord, we do not stand a chance. I'll be very, very candid before your
Why
lordship.
should I interfere?
Because my lord, the only problem
No,
is
in this case, you have been given a hearing and everything. It's your
my lord,
fault.
the only problem is this.
If your client sleeps over it,
No. I'll
help.
show you, lordship. There is an illegality, and that is
not,
why
not today.
the illegality, my lord, I will show.
Not today.
Because they have not seen my GSTR 9.
On 345, I can't see more.
Now this matter
I
is
have to finish my
16.
board also.
This matter is 16. This order, lordship can see. Kothay gelo order ta?
Item number 36.
This order, my lord, was already passed in 16.4.
Which order?
16.4. First order. Now copy the.
16 for today only, we have issued notice. You have seen that.
Yes, exactly. That is here also the same thing happened. No coercive action, AOAR, put to notice.
Which was that same?
Same.
order?
The Python substance is the same.
Just give the dates and orders.
Dates.
The only is that below they have challenged that notification.
Yes,
In
yes.
that petition, they haven't challenged.
Which was that item number?
Item number below.
Just give me the item number.
22. But there, my lord, the notification virus was not under challenge. Here, the notification virus was challenged, is challenged, and both the stalwarts are here, as I have served them. So both of them are here, my lord. This is a case of ultravirus. I have made out a case of ultravirus.
Take down the petitioner has preferred the present petition challenging the ex parte adjudication order dated
Order
15/2/2024, passed under section 73 of the Central Goods and Services Tax Act 2017, whereby the input tax credit pertaining to the financial year 1890 was disallowed under section 64 of the said act, on the ground that the return in the form GSTR 3B for the month of March 2019 has been filed beyond the prescribed statutory limit. Full stop. Learned counsel appearing for the petitioner submits that the legislature subsequently inserted section 16(5) into the CGST Act, where thereby statutorily validating the input tax credit for the relevant financial year where the returns were furnished up to 30/11, right? 30/11/2021. 30/11/2021. It is submitted by the petitioner that he had filed his return on 21/7/2019, which falls well within the statutory extended period. Accordingly, learned counsel for the petitioner submits that the very foundation of the impugned adjudication order no longer survives in view of the subsequent statutory amendment. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition, reply to the same if any within 2 weeks thereafter. In the meantime, the impugned order dated so and so shall remain stayed for a period of 8 weeks or until further order, whichever is earlier. This matter after 6 weeks before the available circuit bench.
I'm grateful to you.
Same as that.
In this matter, I am appearing for CGST, Lordship.
Yes, Mr. Agarwal, where are you? You are appearing online these days. What happened?
No, Lordship.
Your health is okay?
Yes.
Yes.
I had a banter with him on the last occasion yesterday. He said that he will not be coming only for one matter. That is why. Grateful, my lord. It was really a very fantastic experience, my lord, to have your lordship's kind hearing, my lord. I'm so grateful.
Because he's getting all the orders. Otherwise, he would have gone outside and
challenged
criticized
as well. I'm grateful, my lord.
Item number 37.
Deeply alright.
My lord, item number 37.
Yes.
Ayun Banerjee will appear in this matter.
Yes,
My lord.
Mr. Banerjee. What is?
Yes, my lord, item number 37, my lord. This is pertains to, my lord, appointment of staff nursing, my lord. My lord, I
Not
invite
at
you.
this.
My lord,
Not at this time.
my lord,
What is there? State.
We have asked for an explanation, my lord. We didn't receive my lord, as of now, the instructions as.
My lord, last week this matter was appeared, my lord. Kindly. Otherwise,
The West Bengal Health Recruitment Board.
yes, we have served them, sir.
Who
My
appears?
lord,
Who is the main?
my lord, the only difficulty is, my lord, I am a OBC A candidate, my lord. They have treated me as a unreserved candidate, my lord. This is the whole difficulty. I have the certificate with me, my lord. If my lord, learned advocate general, additional advocate general, playing for time, then it can be.
Yes, Mr. Jajit. What is there?
Let's keep it, my lord, Friday, my lord. I'll come back with this.
Friday.
Friday, my lord, only one indulgence, my lord, only one indulgence, Friday top, my lord. Otherwise, it will be very difficult because I have prayed for an interim prayer, my lord. Kindly.
Interim? In recruitment, what interim?
Yes, my lord, I was been arbitrarily excluded, my lord. If there is no protection has
So
been given, then it will be very difficult for me.
All right, we'll see on Friday.
Grateful.
Friday we'll have very few matters, don't worry.
Grateful, lord.
Friday.
Item number 38.
My lord, we are for the petitioner. My lord, we prayer for day after tomorrow, my lord. Report has yet to.
Report has come, but
My lord,
the annexed are illegible, Lordship. That is why.
Let them bring the legible report. But by just one thing, I'd like to draw your.
Yes.
My lord, kindly takes page 25. It's a fantastic case, my lord.
Page?
Where page 25, my lord.
Yes. Yes.
My lord, kindly sees the date and time of seizure. I have never come across such writing of time and date. 0 On 19/1/26/126.
Who was beaten? What had happened? Physical assault? Dressing?
Basically, it is a case counter case. A lot of very fantastic things approach attach this manner. But kindly takes overleaf. Police says that police was assaulted by the petitioners and police received grievous injuries. My lord kindly takes page 26. My lord will find Raj Kishore Das.
Your petitioner is quite bold. He's been beating police officers.
Yes, my lord. Beating police officers, giving the serious and grievous hurt, but the trial court says no visible external injury. And kindly, my lord takes Raj Kishore Das. The incident took place on 19th. 27, my lord. Wang Dorje Lama. He was severely injured. My lord kindly sees the date of medical examination.
Yes, quashing file 482.
Not only that is one limb of our prayer, my lord. Kindly, my lord, just sees for once page 27. My lord, notice the date 17/1/26. And the alleged
18/1.
No, my lord. 17/1/26. Page number 27.
This one.
Lordship, this all the documents of the hospital
Well,
authority,
Lordship,
what
fingers
police will
lies.
do?
Yes.
Wang Dorje Lama. Medical report of Wang Dorje Lama 17/1/2026. The police themselves, the incident took place on 18/1/2026. So the petitioner started beating one day ahead.
Lordship, but the rest are on 18/1/2026. That is why we have come back with the report, Lordship. We also wanted to see. Day after tomorrow, Lordship. We also wanted to see actually what is happened.
Day after.
More facts will come out. At mid-dead of the night, bike and mobile were seized from the road. Abandoned condition. My lord, on Wednesday,
Yes.
if my lord kindly can indicate a time what for this.
Matter comes up.
My lord, if kindly fixes it little higher up in the list. Oh, like.
Item number 39.
Yes, madam.
Your Lordship, I am on the behalf of the petitioner, and this pertains to a cancellation of GST registration, and against which an appeal was also filed, but that was also cancelled. Your Lordship, on the basis of the same footing, Your Lordship had provided us with an order in the case of Ashim Chakraborty versus Union of India, and
Yes, who's appearing on the other side?
we have, and we are preferring the same order passed by Your Lordship in this case as well.
Who's appearing on the other side? Where is she?
The state has been provided with the service.
Tomorrow. Serve them tomorrow.
Grateful, Lordship.
We have passed couple of orders restoring the cancellations.
Lordship?
We have passed couple of orders, similar
Yes, Your
orders.
Lordship. In a similar case, we have.
Yes.
Yeah.
Even day before also there was an order.
Yes, Your Lordship. Shall we provide today or the next?
Tomorrow.
Tomorrow. Grateful, Lordship.
Item number 40.
Item number 40, madam, for the petitioner, madam,
Yes.
service has not yet been completed,
Learned
madam.
counsel for the
Can it
petition.
be fixed on day after tomorrow, madam?
I am appearing on behalf of the national police.
Who you want?
Sir, service upon
Who you
me,
have
my
not
lord.
served?
A special land acquisition officer, DM, both will not be completed.
Learned counsel for the petitioner states that the service has not been effected. She prays for an adjournment. Let this matter be listed day after.
Kindly record my
Absolute. That's why I've recorded one line. Respondent so and so appears. You give your appearance, it will be recorded. It will be recorded.
Item number 41.
And grateful.
Who's there in 41? Not today. None appears for the petitioner in the interest of justice, adverse orders are deferred. Likh do ek line. None appears for the petitioner in the interest of justice, adverse orders are deferred. List on. कल या परसों? कल? Tomorrow. परसों? Pehले list. जल्दी जल्दी.
Item number 42.
Same order.
Item number 43.
Same order.
Item number 44.
Take to appear on behalf of the petitioner. The petitioner is a registered trade unions under the Trade Unions Act 1926, represented by its president. My lord, registration certificate, my lord, will find from annexure P1, page 16. My lord, rules of the constitution governed by its own rules and constitution. My lord, annexure P3, page 18. And my lord, the election of the office bearers is at page 23, annexure P4. My lord, and also the audit report from annexure P5, page 23. My lord, what happened is on 28th of November 21, a meeting was conducted by the members of the trade union. In the meeting, it was strictly decided by the members that those who are not signing up for the membership will be expelled from the union. And it was also duly signed by all the members of the union. My lord will find the resolution from page 33. Thereafter, in 2024, again a meeting was conducted by the members of the trade union that those who did not sign up for the membership and due to the lack of organizational role and due to anti-party activities amounting to the prejudice of the interest of the union are expelled from the aforesaid trade union.
This is your internal fight between the trade unions.
Milord, thereafter, Milord, Milord,
What are you seeking? What do you want?
Thereafter, Milord, still the private respondents are indulging in the, they are expelled, Milord. After the expulsion, they are indulging in the union activities, creating problems, threatening the other members, and intending to split the union. Thereafter, Milord, the president of the union was also threatened, Milord. There are subsequently,
let them go and file a police complaint.
yes, police complaint was filed,
Very good.
FIR was lodged,
Very
page
good.
37. Milord, now what happens is, Milord, respondent number 3 issued a registration certificate in the absence of the union members in favor of the private respondent. From Milord, my lord will find at page 46. That registration certificate, Milord, is without a seal stamp and undated, Milord. Milord, and this certificate
So
was
go before the registrar.
yes,
Cancellation.
Milord, why shall I, Milord? Because I am already holding a registration certificate, and
Very good.
despite
What are
of
you-
the holding a certificate,
Very
I
good.
have they have been issued a registration certificate. Milord, I did not apply for a registration certificate. Thereafter, Milord, my registration certificate is still with me. Thereafter, Milord, the original registration certificate is still in safe custody. There was no loss of the registration certificate. How did the registrar issue a fresh certificate in favor of the private respondent? And with the help of this private registration certificate, they are indulging in the union activities. They are creating nuisance. And Milord, this has caused frustrated to the union members. And Milord, they are forced to leave the union and join some other party. They are intending to break the union. Milord, how did the registrar issue this certificate when there was no loss of the original certificate, when there was no loss, when the members did not apply for a new registration certificate? Milord, thereafter, this is in contrary to the Union Trade Unions Act 1926. And Milord, they are even trying to open a new bank account with this certificate and disturbing the normal functioning of the union.
All right, which is the first certificate which is issued?
Annexure P1, page 16. This is duly stamped and sealed, my lord, page 16, P1. My lord, despite of this certificate, they have issued erroneously another certificate which is undated, unstamped, unsealed. This is issued by the registrar. Issue is 2026. Left hand side from the top, it will appear, my lord. This is a signature and a date is given, and SD eligible. How did this registrar issue the certificate? When the original certificate was valid from 2015? I did not apply for a certificate, neither I have prayed for a loss of my certificate, and neither the certificate is still in the safe custody. And due to this certificate, the other members are misguided. They are all poor tea garden workers, my lord. They are misguided, frustrated, and some of them are even forced to leave the union and join other political organization. Behind the back, they are issuing the certificate, my lord.
Which is the certificate which you are alleging is false?
That is at page 46, annexure P10. This is the certificate which is issued subsequently. Just a date is given, left hand side top, 13 January 2026, without any seal, without any stamp, and unsigned, my lord. With the help of this certificate, they are trying to indulge upon the activities of the union.
Where is your representation to the registrar? Where is the act?
My lord,
Registration Act?
Yes, my lord. I am having, my lord.
Yes. Where is your representation before coming here?
Lord, representation I did not make, but I shall file a fresh representation. Kindly give me the liberty to approach the respondent number 2, that is the commissioner, labor commissioner. I shall file a representation and let it be disposed of. And my lord, kindly make some observations against the subsequent certificate, my lord, registration certificate. My lord, otherwise I'll be praying for interim orders also, my lord. Because of my lord, they are.
You want a dismissal? All right, I'll give you a dismissal.
My lord,
Take down.
they are trying to act upon the barging into.
But you are also acting, much beyond the brief.
I am grateful, my lord.
What do you want?
My lord,
You want to go before the registrar or you want a dismissal of this petition?
my lord, kindly give me a not the registrar, because registrar himself have issued this. Let me go before the labor commissioner.
What does the act say? Show me the act. Where do you go for cancellation of a registration? Come back tomorrow.
My lord, 27, my lord.
Come back tomorrow.
My lord,
Next.
27.
Come back tomorrow.
My lord, it will be sent before the registrar. My lord,
That's what I was saying. You come back
my
tomorrow.
lord, kindly see, my lord.
That's what I'm saying. I know. That's why I was saying go before the registrar. Tomorrow.
Item number 45.
45, we are appealing on behalf of Corporation Legal Municipal. I'm led by Mr. Vijay Vikram.
I'm appealing for the petition.
Yes, Mr. Rahman, what is that?
Oh, it's a very simple issue. I want consideration of my representation. My lord, I'd like to take your lordship to the basic facts. My lord, the petitioner before your lordship is a proprietorship firm.
Change
Is
of
running a
the
nursing
second
home.
floor of the
My lord,
building.
I am running my nursing home in a constructed premises, which is 3-story premises. In the first and second floor, I am running my nursing home. And subsequently, I purchased the said nursing home from the erstwhile owner. The entire construction was purchased up to the second floor. My lord would find my deed of purchase that I have annexed in the writ petition. My lord would find it at, it begins at page 24.
Page?
24. From the erstwhile owner, I purchased it. And after purchasing the said building, which was there, I have constructed the third floor upon that. It was already up till the second floor. And my lord, after purchasing that said property, my lord, I applied for various registrations before the concerned authorities to operate the said premises as a nursing home. My lord would find my various licenses necessary for running a clinical establishment. That begins at page 45, my lord. 45 onwards, this is the license. There is a statutory license. In respect of that premises for running a clinical establishment under the Clinical Establishments Act. Then I have the next page, 46, is the NOC from the Pollution Control Board.
Fire license.
Then thereafter, my lord would find the fire license. That is at page 50. And thereafter,
Trade license 50.
yes, everything is there. my
Then-
lord. Fire license, then trade license, my lord, page 53. This is the fire license, and trade license is 54, my lord. Certificate of enlistment is the trade license. Page 54. And my lord, I am also paying the requisite taxes to the Siliguri Municipal Corporation. That tax receipts I have enclosed from page 55 onwards. My lord, whilst I was carrying on my business of nursing home therein, a complaint was made with regard to the fact that I was running the nursing home in that premises, which was not a commercial premises. A complaint was made in that respect by one individual. And upon that complaint, there was a writ petition filed before this honorable court, and wherein an order was passed upon the Siliguri Municipal Corporation directing the representation of that said person concerned. My lord would take up page number 64. This is the
That's what
order
I'm
that has been
That's what I'm
passed.
reading. That's what I'm reading.
Yes. This is the order that has been passed in terms of the writ petition. Order passed in the
Relevant is at page 68.
the relevant part which had been directed is at page 68. That's the ordering portion. I was directed to immediately stop the use of the second floor of the said building as a nursing home, and I was directed to comply. And subsequent to that, my lord, I have complied with the said order. My lord would take up my letter addressed to the municipal authorities at page 69. My lord, the second paragraph, in terms of the said order and in compliance thereof, I have immediately stopped commercial activities at the second floor. I undertake that no commercial activities shall take place from the second floor of my said building without proper approval and or sanction by the corporation. My lord, what happened thereafter is that I preferred an application before the municipal authorities, that is at page 70. This is my representation before the Commissioner of the Municipal Corporation, allowing me to change the user from residential to seeking permission for change of user from residential to commercial. My lord, this application I have preferred in the month of June 2025. My lord, this representation of mine is yet to be considered. And I just the only
Yes.
one in of course I just considered.
Yes, this can be considered.
My lord, I am
Yes,
appearing.
Mr. Das, again online, what happened? You still have fever? Huh?
We are ready to consider the representation, my lord, which is at page 70.
But why you're not appearing physically? Tell me that. I'm sitting till 4:15. Where are you?
My lord, I am at my chamber.
Mr. Das, you'll be penalized for this.
Namdiji.
He's filling in for Mr. Das.
The commissioner decide this.
You will consider the representation.
Yes,
right?
Lordship.
Grateful.
All
My
right,
lord,
take down.
my
The petition has preferred the present writ petition seeking writ of mandamus directing the concerned respondent
My lord, this is the Commissioner of Siliguri Municipal
to
Corporation.
grant permission to the petitioner under section 273A of the West Bengal Municipal Corporation Act 2006 for change of use of the second floor of the building of the petitioner from residential to commercial. Full stop. Learned counsel for the petitioner states that he has been running a nursing home from the second floor of the building,
First and second.
first and second floor of the building. Full stop. Though a complaint was lodged against the petitioner and subsequently writ petition WPA number 929 of 2024 titled as Shri Satya Ranjan Datta versus Siliguri Municipal Corporation and others was filed before this court. Full stop. This court wide, where's the order of the single judge? Is here?
Yes.
My lord,
No, it's not.
No, it's
it
not
is
here.
not annexed, my lord, but I have the gist of the order is there in the order of the.
In terms of the order passed by this court dated 14th
of,
14th
order
five
dated 14th of May
2025 passed by
2020. 14th May.
In terms of the order, in compliance of the order dated 14/5/2024, the commissioner Siliguri had passed an order dated 20/5/2025, wherein the petitioner has been stopped from using the second floor of the building for commercial purpose vis-a-vis running of the nursing home.
Yes.
Full stop. In compliance of the order passed by the Commissioner Siliguri Municipal Corporation, the petitioner by letter dated 21/5/2025 had written to the concerned authority that he had immediately stopped commercial activities at the second floor and shall not undertake any commercial activities on the second floor of the said building without proper approval or sanction from the corporation. Full stop. Subsequently, the petitioner, by representation dated 4/6/2025 to the Commissioner Siliguri Municipal Corporation, sought change of the land use and permission in terms of section 273 and 273A of the West Bengal Municipal Corporation Act 2006 to use the said building from residential to commercial.
Second floor of the building.
The second floor of the building from residential to commercial. Learned counsel for the petitioner submits that no decision has been taken on his representation dated 4/6/2025. Full stop. Learned counsel for the respondent states that he is ready and willing to consider petitioner's representation dated 4/6/2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. Considering the submissions made by the counsel for the parties and perusing the materials on record, and without entering into the merit of the claim of the petitioner, this court directs the Commissioner Siliguri Municipal Corporation to decide petitioner's representation dated 4/6/2025 within a period of 8 weeks from the date of communication of this order by way of a speaking order,
Well, granting an opportunity of hearing.
granting an opportunity of hearing to the petitioner as well as any other stakeholder.
Great.
Full stop. It is made clear that this court has not expressed any opinion on the merit of the claim of the petitioner and that the Commissioner Siliguri Municipal Corporation shall be at liberty to decide the representation of the petitioner in accordance with law and rules. With the aforesaid direction, the present petition stands disposed of.
Grateful.
Item number 46.
My lord, item number 46 is a peculiar case. Here, my lord, my prayer is investigate my version of the story.
All right, we will
I'm
see
the
peculiar things tomorrow.
process. The issue is
Tomorrow. Not today. Tomorrow. बाकी जल्दी कॉल करो.
Item number 47.
47, Lordship, I am for the
Yes. What is this?
Lordship, here for transfer, Lordship.
Transfer. Which
Lordship.
school to which school? Who's here?
Coastal District, Lordship. Lordship, last hour.
You have made a representation to the authority, school authority. They have given a NOC. Where is your application pending? Online, offline?
Offline, Lordship.
Where is the application pending?
Application dated 28.
Hey, where is it pending? The school has forwarded it.
Lordship is primary teacher, Lordship.
Tomorrow. We'll see tomorrow.
Item number 48.
Lordship, 48, Lordship. Same, Lordship.
Tomorrow.
Item number 49.
49, Lordship, I am for the
Same,
Lordship.
49 tomorrow.
Item number 50.
Lordship, I am for the petition,
Same.
Lordship. Lordship.
50. Very good.
Item number 51.
I represent the state.
Malad, I am for the.
Same. 51
Your lordships can dispose it off because Malad, the application is pending.
Tomorrow there are lot of matters, Mr. Why
Yes, sir.
tomorrow? 51. We'll tomorrow all the matters. What else? 52 also yours?
No, Lordship. 51.
52, my lord, I am for the petitioner, my lord, service has not been completed, my lord, in this matter.
All right, so what do you want? Madam. Sorry, I can't hear you. What?
Next circuit,
What do you
my lord.
want? Next circuit. All right. Learned Counsel Petitioner
Next
states that the
circuit,
service.
my lord.
All right, I heard you. Learned Counsel for the Petitioner states that the service has not been effected upon the respondent. She seeks an adjournment and prays for this matter to be listed before the next available circuit bench. List before the next available circuit.
Item number 53.
My lord, 53, I am for the petition. 53, my lord, I am for the petitioner. My lord, transfer application on medical ground pending before the commission. My lord, SSC
Tomorrow.
medical verification.
Tomorrow.
Item number 54.
My lord, it is also transfer matter tomorrow.
Tomorrow. Transfer matters.
Item number 55.
I'm for the petitioner, my lord, the affidavit of service.
What?
My lord, it's a GST registration cancellation.
So get the orders which I have passed. Tomorrow.
My lord, I have the orders.
Tomorrow.
My lord, leave may be granted to appear virtually. My junior friend will be over here.
Item number
Where
50.
are you? Where are you from?
My lord, I have matter fixed in principal bench. I stay in Kolkata actually. Let it sit.
Item number 56.
Item number 56, I'm appearing on behalf of the petitioner, your lordship.
What is it?
This is my affidavit of service.
First, tell me what is it?
This pertains to transfer your lordship
Transfer tomorrow.
during.
But one small indulgence, my lord, at the cost of getting severely admonished, my lord. But morning I mentioned your lordship desired the wish, why shouldn't I file an appeal, my lord? But I spoke with the client, my lord, we are ready to file an appeal, my lord. My lord, if your lordship can list it, my lord, anytime tomorrow, my lord, that instruction will go.
Which matter?
My lord, the vehicle detention matter, my lord.
Yes.
So, my lord, the only difficulty is it's not an online proceeding. So, your lordship has to direct me to file an offline appeal. That's all. We'll file the appeal.
We have passed it over. What did we do?
No, my lord, your lordship rejected it on the ground, mentioning that I should file an appeal. So, I've taken instruction from the client, my lord. If your lordship can kindly, my lord.
Once I passed an order then.
No, my lord, the order has not been passed, my lord. I was mentioning the matter, my lord, for inclusion, for hearing, my lord.
Alright.
Yes, your lordship said, why shouldn't I file an appeal? So, my lord, I have taken the instruction from the client, my lord. We'll go with the appeal, my lord. We'll file the appeal.
You want the inclusion to be done?
Yes, to kindly list it, my lord. Then your lordship has to direct them. Wait for you.
All right.
Get.
আচ্ছা শুনে নি তো নাম তো শুনি না